Welcome, everybody. Welcome to yet another episode of A Day in the Life of Law of Self-Defense. Thank you all for joining me.
Welcome, everybody. Welcome to yet another episode.
Let me try to fix all this in real time. Hopefully that clickbait title we put on today's content, today's live show, will attract even more than our usual fantastic audience. That would always be greatly appreciated. And of course, we're here today to talk again about the Michael Barisone case, which frankly, in many respects, has been, much of the testimony has been rather trying at times. But I've been taking a peek here and there, and I came across a part so humorous that I thought compelled to share it with all of you in the law of self-defense community. So this is the cross-examination of by defense counsel, of course, of Michael Barisone, of Lauren Kanarek's own attorney. So Lauren Kanarek was a woman shot twice in the chest by Michael Barisone. That's why he's on trial for shooting her twice in the chest, shooting at her boyfriend, Robert Goodwin. 2 counts of attempted murder. I'll do a quick summary of the trial for those of you who may be new to this. New to our coverage of this trial, just so everyone's on the same page. But the reason I wanted to share this with all of you is, one, it's not all that often you see an attorney being subject to cross-examination on the witness stand themselves. Second, there's a dynamic here where the attorney being subject to cross-examination appears to be a perfectly normal human being, an attorney. I know, to the shock of you who think that attorneys by definition cannot be human beings, but seems to be a perfectly reasonable fellow. But defense counsel here is not only apparently very bad at his job, in my perception of his performance in this trial to date, but is quite unreasonable and it is asking such pointless, inane, meaningless questions that he's driving the poor attorney on the witness stand to madness. So we see a number of rather sharp exchanges between Barisone's defense attorney and Lauren Kanarek's attorney on the witness stand. And now, of course, obviously, some of what this attorney, Lauren Kanarek's attorney, would know would fall under privilege. And you'd wonder, doesn't it all fall under privilege? Why is any of this being admitted? It seems he was actually on the phone with Lauren Kanarek and Robert Goodwin while the shooting was taking place, or in the immediate moments around the shooting. So it's that part of his witness testimony that would be admissible in court. Now, we will see there's a portion where I'm going to have to jump ahead in the testimony because defense counsel on cross very quickly tries, I'm speculating, tries to get into areas that are privileged. And immediately, the state objects. The judge excuses the jury, and they have what's called a 104 hearing, which is a hearing, basically a voir dire of this attorney witness outside the hearing of the jury to determine whether or not what he's being asked about from defense counsel ought to be admissible. When we come back from that, and that takes, 20, 30 minutes, something like that, it's off camera. But when the court comes back into session, the judge simply announces that he's determined that what was going to be asked about was privileged, is not admissible. So we're going to skip over that long pause on the proceedings. Now, this was testimony given today. So in the past, when I've been covering this trial, I've been covering testimony given a day or so earlier. This is today's testimony, but what we'll be watching is the recording. So we are delayed from the live broadcast. 401 hearing, sorry, not a 103 hearing. I'm actually not familiar with that number. I think it might be a New Jersey specific figure, but that's how they announced it. The judge actually said 104. So if he misspoke, I claim the privilege to misspeak as well. So this should be quite a bit of fun. I didn't watch the whole thing, so I'm pretty much as naive to this cross-examination of Lauren Kanarek's attorney as all of you. I just saw enough to know it looks like it will be funny. So that's why I decided to do an impromptu live show on this. And after we're done with this attorney's cross, we'll pop back into the real time broadcast of the trial and see what's going on. Now, I believe this is the state's last witness. And then after this attorney, the state rests and the defense will have the opportunity to present its case in chief. And of course, the big question is, are they going to put Michael Barisone on the stand? Because if they don't, it's hard to see how self-defense here would be at all viable. In fact, it's hard to see how they would qualify for a self-defense jury instruction. But I'll circle back. And if they don't do that, I mean, Barisone's done for sure. He probably is anyway, even with the self-defense jury instruction, but certainly without the self-defense jury instruction. Oh, thanks. Someone posted. Yeah. New Jersey rule of evidence for. Oh, okay. Got it. 401 relevant evidence. So that's why they refer to it as such. All right. So unless Barisone takes a stand, he may well not meet his burden of production on self-defense at all, which would be awkward because, of course, it's not really contested that he shot Lauren Kanarek twice in the chest and shot at Robert Goodwin. And if he doesn't have a self-defense justification of self-defense, it's hard to see where he would go, which provides an opportunity for us to do our summary on the events, the facts of this case, the criminal charges, and the prospective legal defenses. A little tea there, having tea today. Hey, Shane, thanks for popping in to do admin duty. I really appreciate it. Before we jump into the meat of today's substance, of course, I should thank our sponsor of today's content, which is, as usual, CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members' legal expenses if the member is involved in a use of force event, and those expenses get big fast, folks. If you've been compelled to kill somebody in defense of yourself or your family, it's not unusual to spend a couple $100,000 in legal expenses before you get to trial, and just multiply that for the trial itself. So if you don't have that kind of money stuffed in a mattress, just in case you have to defend yourself or your family from criminal predation, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal fight the way you want it fought, as if the rest of your life depends on it, because really it does. And by the way, CCW Safe brings a lot more than money to the table. They also bring in your own personal investigative team, staffed by people like their CCW Safe's National Trial Counsel, Don West, who was one of the attorneys for George Zimmerman, staffed by career police homicide detectives who are your detectives for purposes of investigating in the immediate aftermath of your use of force event. And the evidence, the physical evidence, the witness evidence, they can collect in just immediately after your use of force event can go a long way to influencing a prosecutor whether or not to bring charges in the first place. The easiest time to influence the prosecution in this way is immediately after the event. If this happens, attempt to influence happens a month or 6 months later, it's too late by then. The prosecutor's already personally and professionally invested in prosecuting you. So having a team on the ground that's on your side, not just the normal local police investigators who are really working for the prosecutor, can make all the difference. And CCW Safe brings that to the table. Now, having looked at all the companies that offer similar types of quote-unquote self-defense insurance coverage, I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide. But I do urge you to take a look at what CCW Safe has to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can save 10% off the entire first year of your membership using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. I also want to mention, because the first of these is only a couple of days away now, and there's only a couple seats left, mention our upcoming series of Law of Self-Defense Hard to Convict webinars. These are 100% free webinars. We will be engaged in myth busting of many common misconceptions about use of force law and your privilege to use force in defense of yourself, in defense of your family, in defense of your property. If you do your use of force right within the legal boundaries, you have zero criminal liability for that use of force. What you did was simply not a crime. But if you are 1 inch outside that legal boundary, you have 100% criminal liability. And that's it, folks. Self-defense does not exist for you as a legal justification for your use of force. So best to know where the actual legal boundaries are and not be misled into a cage for the rest of your life because you believed a common use of force myth that might have been taught to you by the internet or a gun magazine or a concealed carry instructor or the retired cop down the street. Nobody in your trial cares about what any of those sources told you about the law. They only care about what the law actually is. So best to know that. So we're offering these 100% free webinars. The first of these is in only 2 days, folks, on Wednesday. Excuse me. Little hoarse today. Is on Wednesday, April 6th. We have, I believe, 5 of these scheduled over the course of the month of April. We're not charging a penny for these. It's free to register, free to attend, but there are limited seats, only 100 seats for each of these webinars, and they're filling up fast, folks. I looked just this morning when I checked the figures, we were 65%, sold out on these webinars. Again, they're free. We're not actually selling seats to the webinars. All you have to do is sign up, but we are filling up very, very quickly. I guarantee you from prior experience, these will all sell out very quickly. So if you're at all interested in participating in any of these webinars, and by the way, in addition to the myth busting, we'll do our share of live Q&A from participants as well. So bring your questions. I'll be happy to answer them. If you're at all interested, I urge you to sign up sooner rather than later before all the seats are gone. They're going fast at lawofselfdefense.com/hard to convict. And again, the first of these is in only 2 days, April 6th, folks. So if you're interested, get on it. All right. So little summary of the facts. So here we have Michael Barisone. He's the defendant. He was the owner of a horse farm, horse ranch, horse training facility. Michael Barisone was a former Olympian in the horse riding sport of dressage. I know nothing about horses or dressage, so forgive me, all you horse people out there, if I get those elements of this incorrect. I'm just not that interested in being well informed on horses or dressage, except to provide it as background information here. And Michael Barisone on his horse ranch or farm trained horses and people in this sport. One of those people was Lauren Kanarek. She was interested in this sport. She seems to me a bit above the normal age for being an Olympic athlete, but I'm told that people do dressage all the way into their 60s. She was in her 40s when these events went down, and of course, like the rest of us, hasn't gotten any younger since. She was invited by Michael Barisone to be trained by him and to live on his property, on his horse farm in New Jersey, along with some of her horses. The number of which I guess went up over time. Not that particularly matters, but she brought her boyfriend with her, Robert Goodwin, and pretty quickly the relationship between Michael Barisone, the property owner, and Lauren Kanarek, the student, and her boyfriend, Michael Goodwin, became highly toxic. I mean, brutally toxic. She was saying absolutely vile things about him on social media. She's been quite open about her intention to effectively destroy him emotionally, mentally, professionally, reputationally. Even at one point accused him of child molestation of his own girlfriend's child. So about as vile content as you could possibly imagine, for which there's little or no evidence. I mean, she basically conceded when she was on the witness stand that she wrote all that on social media, but social media is for shit posting, and she was shit posting Michael Barisone, so too bad. I mean, she doesn't feel bad about it in the slightest. Michael Barisone, on his part, appears to have been really emotionally fragile from the start and was effectively destroyed emotionally and psychologically by this woman's conduct. Ultimately, this culminated in a confrontation a couple of years ago where Michael Barisone would wield a pistol and shoot Lauren Kanarek twice in the chest. She would survive those injuries. Obviously, she's testifying in the trial, and shoot at her boyfriend, Robert Goodwin. That would result in 2 attempted murder charges against Michael Barisone. Now, interestingly enough, Michael Barisone himself says Shortly, moments before he fired the shots, when things were really escalating and the crisis of the moment, he basically lost his memory. He doesn't know what happened. He has no recollection until he later wakes up, regains his memory in a hospital or ambulance, wherever it was, after the event. So he himself claims to have no personal memory of firing the shots, which would make a legal defense of self-defense somewhat awkward. Both Lauren Kanarek and her boyfriend Robert Goodwin have testified. They were witnesses for the state. The state is still in the process of presenting its case in chief. If it hasn't yet rested, I expect it will rest today. They both took the witness stand, and they say, of course, that they didn't do anything that would justify Michael Barisone in shooting them. They did come to physical blows with Michael Barisone, but they say that was after they were shot or shot at. So there was beating, there was choking, there was striking with a cell phone, all kinds of stuff that they inflicted on Michael Barisone, but they say that was in the aftermath of the shooting, and therefore, oh, by the way, their dog also bit Michael Barisone, but again, after the shooting, they say, so none of that could be justification for the earlier shooting. If there's evidence that they in some way presented as a reasonably perceived deadly force threat to Michael Barisone, and that's what would justify his use of deadly defensive force on them or at them, it's not in evidence yet. So that is one of the theoretical defenses Michael Barisone could raise here, the legal defense of self-defense. But the legal defense of self-defense requires 5 elements, 5 fundamental elements. This is true not just in New Jersey, but really everywhere in American law. Those elements, I'll share them with you for free, are innocence, imminence, proportionality, avoidance, and reasonableness. Avoidance is usually waived in the U.S. in otherwise lawful cases of self-defense, but New Jersey is one of the 11 duty to retreat states, which means all 5 elements apply in New Jersey. By the way, if you'd like to get a free infographic of those 5 elements, innocence, imminence, proportionality, avoidance, and reasonableness, we make an infographic available for free. Doesn't cost a penny. It's just a PDF download. Doesn't cost anything, folks. And if you don't understand these 5 elements, you can't possibly understand use of force law. These are the building blocks of any claim of self-defense in any state in America, including in this case in New Jersey. Now, sometimes not all 5 elements are required. Sometimes one or more element is waived. Obviously, that's more complexity than we can pack into an infographic. But in New Jersey, all 5 elements will be required. So certainly I urge you, you can't really follow any kind of use of force legal analysis if you don't know these elements. Please download it. You can get it for free at lawofselfdefense.com/elements. But one of the issues in a claim of self-defense is once you've raised that claim of self-defense sufficient to be permitted to argue at a trial, then the burden on the question of self-defense is on the state to disprove self-defense beyond a reasonable doubt. But you do first have to sufficiently raise self-defense to the level required to get it into court in the first place, to have a jury be given an instruction, a jury instruction on self-defense. If that doesn't happen, the jury's never instructed on self-defense. Self-defense does not exist for legal purposes in that trial. And there's nothing for the state to have to disprove beyond a reasonable doubt. So how do you get self-defense as a legal defense into court in the first place? Well, the defendant claiming self-defense has to meet what's called their burden of production. The burden of production is half of the burden of proof. So a burden of proof is both the burden of persuasion, which happens later. Whose job is it to persuade the jury? But before that's ever a concern, you have to get the defense into court in the first place. So the burden of persuasion on self-defense is on the state to disprove self-defense beyond a reasonable doubt. But that burden of persuasion is only put on the state if the defense first meets its burden of production. So what's the burden of production? It's a showing by the defense of some evidence, not a lot, but more than 0 evidence on each of the required elements of self-defense. If any one of these required elements is missing, meaning there's literally 0 evidence, it doesn't exist for legal purposes. And if a required element of self-defense is missing, simply as a strictly technical matter, there can't be self-defense, right? If something requires 5 elements and one of the elements is not there, well, you don't have the elements required for that legal defense. Now, normally, the elements meeting that burden of production is pretty easy for good guy cases of self-defense, because if nothing else, the defendant himself will say, yes, here's my own personal perceptions or claims about what happened. And that's, even if you don't believe it, even if you find it not credible or self-serving, it's more than zero evidence in support of each of those elements, which is all you need to meet your burden of production. So it's not generally hard for good guy cases of self-defense to meet their burden of production. It's not something I would want you to worry about overly much. The consequences of not meeting your burden of production is that you don't have a legal defense of self-defense. Self-defense will not be said in that courtroom. The jury will not be instructed on self-defense. The state will not have to disprove self-defense, which is a problem, because if you were thinking of claiming self-defense at all, the first thing you have to do is concede the underlying conduct. I mean, self-defense is a defense of confession and avoidance. You're not saying it wasn't you. You have an alibi. You were someplace else. You're saying the opposite of that. You're saying it was you. You did it. You fired those shots. You shot that guy. But you did it with the legal justification of self-defense, you're claiming. Well, if the second half of that explanation goes away, if self-defense goes away, all that's left is the first half, which is, I shot that guy. Well, absent a justification, that's simply a confession. So if you can't meet your burden of production on self-defense in something you're claiming was self-defense, you've got a serious problem. It's pretty much a walk-away conviction for the prosecution. So where's the burden of production going to come from here? Because the only witnesses to the event were Michael Barisone, in-person witnesses were Michael Barisone and the victims. And the victims are saying, no, it wasn't self-defense. We threatened him in no way prior to him shooting us. So far, there's zero evidence in support of self-defense. Zero evidence that's not purely speculative in nature. There's no direct witness testimony on it. So unless Michael Barisone is prepared to take the witness stand, it's not clear to me where this burden of production evidence is supposed to come from. So that may mean self-defense is off the table. It may mean that this jury will not be instructed on self-defense. The state will not have to disprove self-defense, and that would seem to be it for Michael Barisone. So I kind of expect Michael Barisone will take the witness stand, except that he's been acting rather like a lunatic throughout the entire trial, sitting there at the defense table, making weird facial gestures and swiveling his head around and just more or less acting like someone who's lost his mind, which may be true. He may have lost his mind, but that's going to make him a less than compelling witness in terms of credibility for this jury, I would expect. So self-defense is beginning to look increasingly problematic for Michael Barisone as a justification for this use of force for all those reasons. Another theoretical defense, another perfect defense, meaning that if believed, it would lead to an acquittal on the criminal liability, would be the insanity defense. But the insanity defense is a pretty high threshold. It basically means you didn't know you were shooting another human being on the facts of this case. It would mean that Michael Barisone was arguing he thought he was shooting aliens or werewolves or robots. And I've not yet seen any evidence that would support anything close to that. Now, the defense is planning to call a psychiatrist and a psychologist as expert witnesses. Maybe they'll provide that kind of testimony. Certainly in the defense opening statement, which was about 45 minutes long, they spent about 90% of that talking either explicitly or implicitly about insanity defense kind of issues. So that does seem to be the core of their defense. They spent about 5% of their time mentioning self-defense type stuff, but even the defense in their opening did not say that the beating Michael Barisone was subject to occurred before he shot at the victims here. Even the defense didn't claim that in opening. So even to the extent they talked about self-defense, it does not appear to me that they really have much meat to work with there. Insanity seems like a stretch. I don't think anyone really believes that Michael Barisone thought he was shooting anything except another human being, absent apparently justification, which that's not insanity. That's just someone shooting another person unlawfully. Now there is a couple of imperfect defenses here. An imperfect. Oh, by the way, if he is found not guilty on the grounds of insanity, he's not simply released into the world. What happens then is he would be institutionalized indefinitely until his doctors determined he was no longer a threat to the public. And that might be, I don't know, soon, or it might be never. So it's a very ambiguous sentence of confinement, just not in a prison. So those are the perfect defenses: self-defense and insanity, which, if believed, would lead to zero criminal liability. In the case of insanity, obviously subject to that institutionalization. There are imperfect defenses, and imperfect defense is one that cannot lead to an acquittal, but could mitigate murder, or in this case, attempted murder, down to manslaughter or attempted manslaughter on the facts of this case, on the charges of this case. And there's a couple ways to get to imperfect self-defense. In imperfect defense here. One of those is a doctrine called imperfect self-defense. So imperfect self-defense is different than self-defense in that self-defense has all the required elements, including reasonableness. And one of the requirements of reasonableness, that your use of force was reasonable, is that it was objectively reasonable, that a hypothetical, reasonable, and prudent person in your position would have shared your subjective belief that you needed to use that force in self-defense. But what if you have the subjective belief? What if you had a genuine, good faith, subjective belief in the need to use force in self-defense, but that belief was not objectively reasonable? It was irrational. It was unreasonable. So you believed it, but a hypothetical, reasonable, and prudent person in your position would not have felt that way. Well, then it's not self-defense, because self-defense requires both the genuine good faith subjective belief, but also that belief be objectively reasonable. So if you're missing objective reasonableness, you can't have self-defense. You don't have that perfect defense of self-defense that could lead to an acquittal. You can have imperfect self-defense. And what imperfect self-defense says is, hey, if the only defect in your claim of self-defense is that it wasn't objectively reasonable, well, we're not going to acquit you on that. You don't have self-defense by definition, but we will mitigate what would have been murder to manslaughter, or in this case, attempted murder to attempted manslaughter. Another way you might be able to get to a mitigation here, another form of an imperfect defense, not acquittal, but mitigation, it's on the grounds of diminished capacity, essentially that the emotional and psychological torture to which Michael Barisone had been subject by Lauren Kanarek and Robert Goodwin had so severely damaged him emotionally and psychologically that he lacked the ability to form the murderous intent required for an attempted murder conviction. And because he had diminished capacity in that respect, at the most, you could convict him of attempted manslaughter. That could be an argument his defense counsel could make at closing as well. And then there's a wish. The last defense, and I should put defense in scare quotes, is it really appears that these people, Lauren Kanarek and Robert Goodwin, treated this defendant, Michael Barisone, horrifically, monstrously. And the defense might simply argue to the jury that, listen, this guy, my client, he ought not have done this. He ought not have shot Lauren Kanarek and shot at Robert Goodwin. We're not going to justify that as self-defense. And he's not crazy enough to qualify for insanity, or at least if you believe it wasn't self-defense and you believe, ladies and gentlemen of the jury, that it wasn't insanity, at least cut our client a break, because he would never have done this but for their torture of him. But that's not a legal argument. That's an emotional argument. So maybe the defense will go that route as well. It's kind of a, if the glove don't fit, you must acquit kind of argument. I mean, that worked in OJ, right? But I'm not sure this defense attorney is at the level of OJ's defense attorneys, to put it mildly. And I should touch upon that before we proceed. So I haven't watched the entirety of this case by any means. I did watch the state's opening and closing statements. I watched the cross-examination of Lauren Kanarek and the cross-examination of Robert Goodwin, the other in-person witnesses and victims in this event. And so I've seen the defense attorney's performance in those contexts. And frankly, it's been absolutely horrific. Now, I haven't looked up this attorney's background myself. I'm told in the comments that he was a former federal prosecutor, that he has something like 30 years experience in criminal law, criminal trial law. I find that extremely hard to believe, unless he was somehow struck in the head with an anvil just before this trial, because I've seen nothing in this guy's performance that couldn't be equaled or exceeded by a reasonably competent paralegal. it's just bad. These cross examinations have been absolutely train wrecks, and just poor performance by the attorney. Vague, ambiguous, compound questions, attempting to argue points of fact that aren't really relevant to either the criminal charges or the legal defenses, compelling the judge to continually correct him on his conduct in cross-examination. It's just been a total train wreck. I'm not going to go over all that in detail because, well, you could always go back and watch my live shows on those portions of the trial. Plus, I expect we'll see more of that shortly now as we get into this defense attorney's cross-examination of Lauren Kanarek's lawyer. Yeah, so people keep making comparisons to B. Ivory Lamar in the Theodore Edgecombe case, who was also, in my opinion, again, I don't know B. Ivory, I don't know his career. I only know his performance in that trial. It was not good. Just not a very good attorney based on that exposure. But at least B. Ivory brought theater to the courtroom, and there's value to theater. It's not it's not the practice of law, but you can salvage a case sometimes with pure theater, and B. Ivory brought plenty of that to the trial. This defense counsel is just, by all appearances, not good, and there's no theater, which is at least one level below B. Ivory. Also, as we go through all this, as always, I am perfectly happy to answer questions. What just happened? Test, test, test. Sorry, I thought I hit a button on my sound bar and my ears exploded. I'm perfectly happy to answer questions, but I can't just scroll through the thousands of things that are in the chat. I mean, there's an avalanche of stuff in the chat flowing all the time. So if you have a question that's important enough, you'd like to have it answered, I would urge you to make it a super chat. And I promise to answer all of those before we exit the show. And it looks like none of those so far. So that's good. Let's see. Anything else I need to touch on before we jump into the actual cross? All right. I think that's fine. So let me go ahead and pull up that screen. So this is the attorney, Lauren Kanarek's attorney on the witness stand. First of all, one thing I'll note is on the breaks, I'm not sure if we'll catch this or not. On the breaks, this lawyer on the witness stand and the judge have been chatting back and forth about a golf competition that's currently taking place at some length. Apparently, they're both golf fans, and they have been chatting quite amiably about this. I don't know if it's the Masters or what it is. I don't follow golf myself, folks. To my eye, every golf course, as pretty as they are, is a wasted rifle range. But nevertheless, it's remarkable how you don't often see the judge chatting in that much detail and length with a witness on the stand as I've seen here. The other remarkable thing is I can't believe, am I just old? But I can't believe that this guy's a lawyer would show up to testify in court, which is unusual enough, and is not wearing a tie. I mean, I wouldn't be there without a suit on, much less just a tie. I mean, it looks like he's dressed to go play golf. Maybe I'm old enough that I don't know. I mean, when just last week, I was at the 2022 Tactical Conference in Dallas teaching law self-defense stuff. And guess what, folks? I'm on a gun range and I wore a tie to teach that stuff. If I'm doing lawyer stuff, I'm wearing a tie. In any case, here we are. So I'm going to go ahead and start direct questioning of this guy just finished. The judge is just handing it to cross. So we'll start with cross-examination here where there's apparently big gaps in the testimony, like for that 401/104 hearing stuff. I'll skip past all of that. All right, folks, let's jump in.
cross-examination.
Mr. David, you basically knew Lauren Kanarek.
By the way, for those of you who are new here, because this just pees me off so much, all that pen clicking and paper wrestling and sighing you're hearing in the background, that's not me. That's this judge. He's incessantly doing that, apparently 2 inches away from his microphone on the bench. I'm sorry about that. And all that noise tends to drown out the actual questioning and testimony by the lawyers and the witnesses. I've got the volume as cranked up as I can make it without the pen clicking deafening all of us. So I apologize for that ahead of time.
Back for a day prior to this incident, correct?
A day or two, yes.
And did you ever meet with her?
I did.
You met with her on the 6th, correct?
I recall meeting with her. I couldn't tell you the date.
The day before the shooting, perhaps?
I believe so, yes.
And is that the first time that you ever met with Lauren Kanarek?
Person to person, yes.
Had you talked?
So just to clarify, this is the lawyer who was apparently retained by Lauren Kanarek for the purpose of her dispute, her tenant dispute with Michael Barisone. So Michael Barisone, once the relationship became toxic, he'd been asking her to leave his horse farm. She refused. And unfortunately, because he invited her to live on the property, she is a legal tenant there. And she doesn't have to leave just because she's asked. Now, ultimately, I think just the day before the actual shooting, he finally got an eviction order for her. But, you know, eviction order doesn't mean you suddenly you press a button and the person sprung out of the property. The tenant has a right to contest the eviction notice. So it takes a long time. In New Jersey, it can take months before you actually can get a court order and a sheriff to come out and physically remove someone, compel them to leave the property. And that's what she was doing. She had retained a lawyer, this guy, to assert her rights as a tenant. Now, in hindsight, we can all look back and say, hey, if she hadn't tortured this guy mentally and psychologically and had simply left the property, none of this had to happen. That's true, but hindsight doesn't matter. So she refused to leave. She had not left, and that's one of the reasons everything culminated. And this was her lawyer for that purpose. Now, apparently, one thing we'll see a lot in this cross-examination is this defense lawyer really drilling in on things that just don't matter. It'll be things like, so when you first met your client, was it 9 a.m. or was it 9:05 a.m.? Or when this call happened, did you call her or did she call you? And the lawyer's memory of some of that is ambiguous. I mean, he just can't recall, or maybe he put somewhere in the record, he said, I called her, and elsewhere he said she called me, and it's inconsistent. But it's a prior inconsistent statement on something that has absolutely no relevance to this shooting. And this defense lawyer drilling in on ambiguities. Sorry, folks. It is just tea. It's not vodka. This defense lawyer drilling in on these ambiguities or inconsistencies on things that just don't matter. Frankly, it's reminiscent of what a criminal defense attorney does when he's got no case at all, when his client's just a criminal and clearly guilty based on all the evidence, clearly guilty. So you ask these kinds of silly questions about things that don't matter in the hope that the jury will misconclude that there's some uncertainty here, that there's some reasonable doubt here. It's maddening, and it's maddening to this attorney on the witness stand, and we'll see that escalating over the course of this cross. Hey, this is being broadcast live on Law and Crime, so anyone who doesn't like the way I'm covering this, you can just piss off and go watch it on Law and Crime. No offense.
Spoke to her on the phone prior to that.
I believe I had.
How many times?
I don't recall.
Who retained you?
Well, Lauren was my client, but I believe her father, John, made the connection.
Was Robert Goodwin a client of yours?
No, I don't believe so.
Now, on that day, on the 6th, were you aware that Robert Goodwin tape recorded your entire meeting on that day?
I was not aware of that at the time, no.
Are you aware of that now?
I am aware of that now.
Did the prosecutor give you a copy of the transcript of the meeting on August 6th?
The meeting,
By the way, I should mention, because somebody in the comments mentioned the law and crime chat. Apparently, the judges ordered Law and Crime to shut down their chat. I don't know why for a fact, but it may be. I'm hearing. I mean, I don't watch Law and Crime. I don't know why anybody would. I mean, just look at their numbers. Apparently, very few people do. But it appears that the chatters on Law and Crime have concluded that this trial judge here is completely biased against the defense because he keeps checking. Almost body checking the defense counsel here. It's not because the judge is biased. The judge, if anything, is quite restrained, in my opinion. It's because this defense attorney keeps stepping over the line, and it's a judge's job. It's his duty to keep that from happening. But apparently they were talking such shit about the trial judge that I don't know, maybe the judge was made aware of that, but in any case, he ordered them to shut their chat. And now if you look at Law and Crime in their little description below the video stream, it says right there, we've been ordered to shut down our chat. They don't say exactly why, just ordered by the judge. And then they add, maybe as a knock against Nick Rekieta or me, though I don't think they know I exist, they add and we follow judges' orders to be sure that we can continue to have cameras in courtrooms. I mean, oh my God, talk about a Karen-esque childlike conduct by a multi-million-dollar media organization. But nevertheless, there's no chat at Law and Crime, to my knowledge. At least there wasn't when I checked earlier. So if you'd like to chat, be here. And if you don't like how we do things here, then, be elsewhere.
between Lauren and I? No. I've never seen it, nor do I know the content of it.
Now, on the 6th, and correct me if I'm wrong, it was you, Lauren Kanarek, Robert Goodwin, and Lauren Kanarek's father, correct?
I don't recall Robert Goodwin being there, but if you say he was, I wouldn't dispute it. It's possible.
Were you informed at any point that they were recording private conversations during that meeting?
Judge, I'm going to object that this is beyond the scope of the direct examination. I understand there was, maybe we can come to sidebar.
Yeah. Lots of sidebars in this trial. and largely driven by this defense counsel's conduct. I mean, when you're on cross, at least in New Jersey, not every state does this, but the tradition is you have direct questioning of a witness, and it covers topics A, B, C, and D, for example. And then on cross-examination, you're only allowed to ask about A, B, C, and D. You're only allowed to ask about what was questioned about on direct. So if direct was topics A, B, C, and D, cross can cover A, B, C, and D. Often, cross will cover just A, B, C, for example. And then if there's a redirect, the redirect can also only cover A, B, C. But let's imagine redirect only covers A and B. Well, then if there's a recross, it can only cover A and B. So each stage of the direct, cross, redirect, recross is traditionally only supposed to cover within the scope of the prior level. Here, of course, we're at the top level. We just had direct. And now the defense counsel is attempting to ask about topics that were not asked about on direct. And that's the objection here. Not every state does this. That's the traditional way. Apparently, New Jersey does. That's the basis for the objection. Frankly, I prefer it that way because it constrains each level and you don't end up at 48 levels of recross examination of a witness. But in any case, this defense attorney would know this. He would know that he's not supposed to be asking on cross outside the scope of direct. Or he should know. Maybe he doesn't know. Just like he doesn't seem to know what hearsay evidence is. And he keeps asking about that. Or he doesn't seem to understand or recall that the judge has already told him he can't ask about a certain area of evidence that the judge has already ordered is not admissible, and he does it anyway. I mean, these are just a few of the many reasons the judge has had to continue to check this defense counsel. That's not an indication of bias of this judge. It's just him managing appropriately, I would suggest, his courtroom from the chaos. This defense attorney, either intentionally or I suspect unintentionally, is attempting to inject into these proceedings. All right, I'm going to fast forward a little bit until we get, oh, there we go. Not quite yet. Not quite yet. All right, here we go.
Sir, you had a meeting with Lauren Kanarek and her father the day before the shooting, correct?
Yes.
And isn't it a fact that during that meeting, for the first time, you were appraised that recordings were being made of?
So just a pet peeve here. He wasn't appraised. He was apprised. Appraised is a completely different word, but this defense attorney likes the word appraised where he should be saying apprised.
Private conversations.
No. That is not true.
Okay, what were you appraised of with regards to private conversations?
Nothing. Let me rephrase that. Nothing that I recall.
I have only very limited control over the trial volume, folks. Sorry about that.
Can we go to the sidebar again?
Sure.
So I believe this is a very lengthy sidebar. This is where the defense attorney is trying to get into areas that either could be, I mean, I don't know. They do these off mic. So of course I'm speculating a bit here. Either a bit here. Either the prosecution felt like the defense was perhaps getting ready to go into areas that were privileged, or to ask about things that this witness has already said he doesn't know anything about, and would be obliging the witness to attempt to speculate. Speculation is not allowed in court. You're supposed to be testifying about your personal knowledge of events, not just guessing about what happened. In any case, after this quite lengthy break, I'm going to fast forward. Whoop. Yeah, so here the judge is standing because he's excusing the jury. They're going to have this 104/401 hearing about the intended line of questioning and the anticipated answers outside the hearing of the jury, so they can voir dire this witness and determine whether or not that testimony would be admissible. Spoiler.
Mr. David, the court decided based on.
Spoiler, the court decided it was not admissible, as the judge will say here. Well, the court has muted the judge's own microphone, so I'm going to go ahead. This is where they're having that hearing. So the court hasn't decided yet, but when they come back, the court will have decided. Here we go. Here's the judge again. Oh, I'm going to rewind this. This is where we hear the judge and the witness chatting about golf. I mean, they're whispering. I don't know if you'll be able to hear it because the court's already pretty quiet. I can hear it through my earbuds. It should happen. It should happen right about here. Here we go. So you don't normally see this either. Don't normally see a lawyer being subject to cross, and don't normally see a judge and a witness chatting so amiably as we do here. Come on, judge. Here we go.
Ms. Radler, are the jurors coming in? Yes, sir. All right, thank you.
Love your cup.
Thank you. It's Masters Week. You a golfer?
Tiger gonna play or not?
I don't know. I hope so.
Me too. Not since Hogan.
I don't think he'd win, but I think if he's in contention, it would just be
It would be unbelievable. Right. It would be his big as his win 2 years ago,
Yeah.
or 3 years, whatever.
I mean, these guys are aroused over the prospect of Tiger playing in this golf tournament. It's whatever. All right, I think that's the end of the golf chat. Let me get back up to the.
That's correct.
Whoop. Get back up to the cross of this.
Before we broke,
Okay.
you indicated that you have no recollection of discussing Lauren Kanarek tape recording Michael Barisone or others during your meeting, correct?
That's correct.
Now, you called 911, correct?
I did.
You gave a statement to the Morris County Prosecutor's Office on September 16th, 2019. Do you recall that?
I do.
And can I assume that you reviewed that with the prosecutor?
No, you cannot assume that.
Did you get a copy of it?
I did not.
Now, after you heard whatever you heard on the telephone, did you make notes of that conversation?
Well, after the fact, I was in a car when it happened. So I did not take notes, and I didn't get back to my office till later that day.
And can I assume that later that day, after going through something like this, as a lawyer, you wrote down everything that you remember in case someone would want to question you about?
Why would you assume
I know
anything?
I did it. I can't tell you when.
You can't tell me whether it was the same day or some days after, correct?
It was within, my guess, and it's pure guess, within 24 hours, maybe 36 hours,
Okay.
something I wouldn't forget. I mean, the whole thing lasted a minute or two.
Okay, well,
Our conversation, understand, was pretty one-sided, and it happened over the course of 10 or 15 seconds. There wasn't much to remember, but I remember writing down everything she said,
okay.
right? Everything I could remember.
All right. So within 24 hours, your best estimate, you write down everything that you specifically recall with regards to this conversation, correct?
Yes,
Did you give those notes to the prosecutor's office?
I did.
Here's where the lawyer on the witness stand gets increasingly.
Do you recall
He
telling the
did.
prosecutor's office in your official statement that you destroyed the original notes?
No, but I likely did. Oh, well, I'm certain I did.
Okay, didn't you just say you gave those original notes to the Morris County Prosecutor's Office?
No, you just said that, and I agree. If you allow me to rephrase it, I gave them a copy of the notes. The originals, understand, my office is a green office. I don't keep hard copies of anything. As soon as I have a document, even one that I've prepared, I scan it into the computer and destroy it. I don't have the capacity to keep 40 years of records in an office. So I do not keep an original of anything. So that is, for all intents and purposes, as the courts of this state have recognized, appropriate.
I'm going to show you D 1200D.
Okay.
Do you recognize that?
I do.
Are these notes that you drafted regarding this incident?
They are.
Are these the notes you just testified you put down approximately 24 hours or so after the incident?
Yes. But I signed it apparently much later.
When did you sign it?
Apparently much later.
When did you sign it?
It is dated September 16th, 2019.
Does that refresh your recollection that you signed it on that day in September?
I just said I did. But there's a reason for that.
Oh.
If you'd like me to explain it, I'm happy to do that.
What day did you give your statement to the prosecutor's office?
I don't recall.
I show you a copy of your statement, D 1200C, and ask you if this refreshes your recollection as to when you talked to the prosecutor regarding this specific instance.
Yes,
Okay, and what day did you talk to the prosecutor's office?
September 16th, 2019. And that's why I signed it this date. Because I sent this to them, I assume, on this date. But I scanned it into my computer, and I could probably dig up the date of the scan at or around the time that I wrote it. Because that is what I do 100% of the time. I take notes, I scan it into my computer. I didn't think I had to date the notes. But when I spoke to the prosecutor's office and they wanted a copy of it, I signed it, I dated it, and I put the time.
All right. So first of all, does anybody think
Sure.
any of this matters?
Now,
That's what I recall anyway.
Precisely when? Anyone think it matters precisely when he signed a piece of paper or scanned a piece of paper? Is that relevant to the legal charges of attempted murder or the criminal defenses of self-defense, insanity, diminished capacity, imperfect self-defense? None of this matters. And it's the kind of silly details that nobody would remember exactly. I mean, this is all entirely irrelevant. And the lawyer's asking is if there's something wrong with this defense witness lawyer for not being able to recollect these details, or suggesting you destroyed the originals, as if there were something wrong with that. Not only doesn't it matter, but there's nothing wrong with any of that. That's just the normal practice of law.
now, prior to this incident, you had a number of conversations with Michael Barisone's lawyer, Stephen Tarshish, correct?
Prior to when?
Prior to the shooting.
Yes.
And was it your impression that he and you were in the process of working out Lauren Kanarek leaving the property?
We were working out a settlement of the dispute. One of the issues that we needed to resolve was if and when Lauren would leave the property.
You also mentioned something about Facebook posts. Prior to that meeting, had you received some of Lauren Kanarek's Facebook posts?
Judge, I'm going to again object that this is beyond the scope of the direct examination.
It is somewhat beyond the scope, Mr. Belinkus.
All right. Now, on the day of the incident, did you call Rob Goodwin or did he call you?
I believe I called him.
Do you recall telling the police in your official statement that you're not sure whether you reached out to Lauren or whether Rob called you?
I don't specifically recall that, but understand, I was in somewhat of an extremis. I had just been on the telephone when I heard gunshots and my client telling me she's been shot in the chest. I wasn't exactly focusing on who called whom at that very moment.
Well, you were very definitive in court today with regards to who called who, correct?
Correct.
And would you agree with me on page 7 of the transcript?
I'm back. Yeah, sorry, folks. Trying to figure out why that link wasn't working.
Yeah.
That first webinar, by the way, the free webinar, Hard
Yeah.
to Convict.
I
First
even
one is
reached out to
Wednesday,
Lauren where Rob
April
called
6th,
in.
2 days
Yeah,
from now. They're
okay.
filling up fast. It's over almost
That's
3/4
different
full.
than the definitive answer that you gave on direct.
Well, I
correct?
would assume you have the copies of the telephone records that would determine who called whom, right? I mean, how hard is that to get?
Not hard.
Oh yeah, you don't usually get this in court. So obviously the defense counsel here is asking about inanities. Who called who? Who cares who called who? What's that got to do with it? What this lawyer wasn't conspiring against Michael Barisone. He was just an ear witness. He was just on the phone. What difference does it make who called who to the attempted murder charges or the legal defenses? It's just crazy. And the lawyer on the witness stand really doesn't like it.
At all, but I'm
Okay.
asking
All right,
you-
hold on a second. Getting a little argumentative here. Just answer the questions. If there's any follow-up, Mr. Shellhorn can ask you questions.
I have thought about it, and of course, I called Rob. So if I said at this moment, when I was in extremis, that I didn't recall whether I called him or he called her, that wasn't the first thing on my mind. The first thing on my mind was reporting that my client's been shot by your client. So that's what really was important to me at that moment, not who called whom.
Do you remember telling the prosecutor that I think I reached out to him, but I couldn't swear, correct?
I don't recall that. If it's in the transcript, I assume I said it. Again, in extremis.
Right now, irrespective of who called who, you're talking to Rob Goodwin, correct?
Correct.
And what did you say to Rob Goodwin?
Rob, can I speak to Lauren?
And Lauren's the one who's in control of everything, correct? Based on your
I don't know what that
dealings with her.
means. Lauren was my client. So I was calling to speak to Lauren.
Did you say to the
So another
prosecutor's office,
example
words
of
to you-
how ambiguous this defense counsel is. That's why this lawyer says, I don't know what that means.
Client's been shot by your client.
Rewind it
So
just a minute to highlight
That's
that.
what really was important to me at that moment, not who called whom.
Do you remember telling the prosecutor that I think I reached out to him, but I couldn't swear, correct?
I don't recall that. If it's in the transcript, I assume I said it. Again, in extremis.
Right now, irrespective of who called who, you're talking to Rob Goodwin, correct?
Correct.
And what did you say to Rob Goodwin?
Rob, can I speak to Lauren?
And Lauren's the one who's in control of everything, correct?
Lauren's the one who's in control of everything. What does that mean? She's clearly not in control of everything, right? So this defense counsel has something in his head that maybe he thinks he's asking about, but it's a kind of ambiguous questioning that, first of all, can't get you anywhere. Second of all, will lead to responses you may not like, and third of all, opens up the door for the witness simply to answer in ways they prefer that arguably answer your ambiguous question, but maybe are not helpful for your client, and still in a way where they can't be held accountable for having lied. Because if it's an ambiguous question, it's open to 1,000 different answers, all of which are arguably truthful. Dear Lord, so Lauren is in charge of all the things.
Based on your
I don't know what that
dealings with her.
means. Lauren was my client. So I was calling to speak to Lauren.
Did you say to the prosecutor's office words to the effect that if you get to know Rob, you'll know that Lauren was the one who actually was really handling this? you
Yeah.
make a statement like that?
I certainly could have. Lauren was going to make the decision. She was my client.
You're talking to Rob, and
At what
that
point? At what point?
when you first got on the phone, you were talking to Rob Goodwin, correct?
I said 4 words to him.
Okay, and then the phone was put in Lauren's hand, correct?
Correct.
Do you recall Rob yelling in the background?
Oh, look, they got a skinnier bailiff.
Or
This guy does
speaking
not eat
loudly?
Jersey Mike's.
Either one.
Or maybe he's just young.
Specifically, no.
I asked you to turn to page 9. The 6th ed from the top. Can you read it and see if that refreshes your recollection as to after you were talking to Lauren Kanarek, you heard Rob yelling in the background or talking loudly?
Yeah, I see that.
And then could you go down 1, 2, 3 more eds? And then did you say, or
What-
do you recall, strike that?
Yeah,
Did
are you refreshing his
do you-
recollection?
right. Do you recall hearing a gunshot at that?
Maybe the Washington Township Police Department?
Did you have a discussion with them with regard?
Well, I don't know what just happened there. There was kind of a jump. I'm going to rewind a little bit, see if that happens again. That wasn't me, folks. But what the defense would like to get to here is some suggestion that there was some fighting or argument happening on the phone that this lawyer could hear over the phone prior to the shot being fired. That would be consistent with the narrative of self-defense. The other thing this defense lawyer loves to do all the time is provide testimony himself. So say words himself, the defense counsel, that ought to be, if he's lucky, ought to be said instead by the witness in response to his questioning of the witness. That's why the judge just checked defense counsel again appropriately on that.
Yeah, I see that.
And then could you go down 1, 2, 3 more eds? And then did you say, or
What-
do you recall, strike that?
Yeah,
Did
are
you-
you refreshing
do
his
you-
recollection?
Right. Do you recall hearing a gunshot at that?
Maybe the Washington Township Police Department?
That jump is long, crime folks. Sorry about that. It's not on my end. Just wanted to make sure.
Did you have a discussion with them with regards to this incident?
I was trying to get somebody on the phone. It actually may have been, and no recollection of who told me, but I reached out to John and Kirby Kanarek, Lauren's parents. I reached out to the Washington Township Police Department.
And did all these people tell you that Lauren Kanarek had been shot?
Somebody told me that Lauren Kanarek had been shot. I don't know if all of them told me. I know I spoke to all of them at some point within that gestalt, but couldn't.
Does it matter? Does it matter at all how many of them told him that she'd been shot? Does it matter if any of them or none of them or all of them told him that she'd been shot? Was she not nevertheless shot? Does this have anything to do with anything?
tell you definitively who told me that Lauren actually had been shot.
Do you recall telling the prosecutor's office that when you heard whatever you heard, you didn't think gunshot?
No, I don't recall saying it, but I'm certain that that's what happened because you don't believe gunshot. I'm driving up 280 trying to speak to my client. That's all. So imagine how out of worldly it would be to hear what you think are gunshots, but you just don't believe it. And I just didn't, you don't want to believe it, but I believed it enough to call 911 right away.
Does it matter whether he believes it? I mean, she had 2 gunshot wounds.
So something inside me must have said to yourself, this could be real.
Or either that, and correct me if I'm wrong, or Lauren Kanarek saying that she was shot.
Well, we know Lauren was shot. So,
Well, how do you know Lauren is shot at that point?
at that very moment, because she told me she was shot.
Okay, and did you tell the prosecutor that you did not think gunshot when you gave your statement? Yes or no?
All right. So, in fairness to defense counsel here, he could be arguing just the timing. If he's planning to argue that, for example, I mean, there's been no evidence to support this. So far, the only suggestion of any of this is this kind of speculative questioning by defense counsel. But if he's trying to suggest that the victims here lied about when they were shot, so they said they were shot, then they beat up Michael Barisone, and it's only after that that Michael Barisone actually shot the victims. So that when he shot them, he was, in fact, it was already after he'd been the victim of an attack by Lauren Kanarek and her boyfriend, Robert Goodwin. Could that theoretically happen? I mean, they called up their lawyer, or they got, in fact, I think it was the lawyer said he called them. So they're waiting for a random call from their lawyer, unless this lawyer is also supposed to be a co-conspirator in all this. But the lawyer's on the phone and they say, bang, I've been shot. And it's not true. They're fabricating that. And then they attack Michael Barisone. And then, only then do they get shot for their attack upon Michael Barisone. I mean, even Michael Barisone's not saying any of that. I guess, you go for the wish.
I can't answer that question, yes or no.
Can you refer to page 9 of the transcript, the second ed from the bottom, and tell me whether that refreshes your recollection with regards to whether you told the Morris County Prosecutor's Office that after you heard Rob Goodwin yelling, you hear something, but you don't think gunshot.
As I explained to you before, when something so out of context occurs, you don't immediately go to something that in your wildest imagination could occur, right?
By the way, this should not be allowed. I mean, this defense attorney should not be allowing this witness to testify in this way. This is cross-examination. You're asking the lengthy questions and you're getting short, direct answers back from the witness. I mean, in a perfect world, on cross, the answers are all yes, no. You don't allow on cross the witness to go into these long expository narratives that are harmful to your client. If he wants to give those kinds of explanations, he can do it on direct or redirect. On cross, you're supposed to be managing that hostile witness's testimony. You don't just let him blah, 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 blah. And that's on this defense attorney. He does this repeatedly throughout. He did this on the cross of Lauren Kanarek. He did this on the cross of Robert Goodwin. It's like he doesn't know what cross-examination means.
If it has stripes and hooves, you think zebra, right? I wasn't thinking gunshot. There was no reason to think gunshot, but obviously I must have, because I called 911.
Do you recall telling anyone that the noise that you heard sounded like something heavy dropping?
No. I don't think I ever told anybody that.
At that point, after you hear whatever you hear, did you say the phone dropped at that point?
Yes.
And was that immediately after you hearing whatever you heard?
No.
When was that?
Maybe 10 seconds later.
10
After she
seconds?
said, I've been shot in the heart, words to that effect. Then I'm saying, Lauren, what's going on? What's that? Hello?
Shot through the
I heard
heart,
what I thought
and
was the
you're
phone
to
dropping.
blame.
And that's
We get
approximately
the little New Jersey
10
John Bovey on here.
seconds after you hear what you hear, correct?
10, 15 seconds, yeah.
And At that point, you hear scuffling, correct?
Yes. But then I hung up.
At some point in time, after you believed you heard the phone drop, did you hear someone pick up the phone?
I don't recall.
When you look at page 10, the last ad on the bottom,
Page 10. Yeah. Oh, so that's how it happened. Okay. That's possible. So,
when you say, let me ask you
Yeah,
ask a
mhm.
question. You say you heard what you thought the phone dropped, correct?
yes, now this refreshed my recollection.
At some point in time,
Mhm.
did someone pick up that phone?
I said here the phone must have been picked up.
Okay, now let me ask you a question. That was after you heard whatever sound you heard, correct?
Yes, that's for sure. I heard the sound first.
And is that when, at that point, Lauren Kanarek makes the statements she
Yes.
made to you?
Okay, yes.
So you were incorrect on your previous.
I stand corrected, yes. Gotta understand, this was 4 years ago, and I haven't looked at this in 4 years.
And after Lauren Kanarek makes the statements, strike that, did she say, "I'm losing consciousness"?
She might have.
Can you look on page 11? 4 edge from the bottom, and see if that refreshes your recollection as to whether one of the things that Lauren Kanarek said to you is, "I'm losing consciousness."
Yes, yeah, it does refresh my
And you
recollection.
recall her saying that, correct?
Yes,
Did the phone drop again after that statement?
well, I think so, because at some point I realized she wasn't on the other end of the phone any longer. And that's when I disconnected the call and I believe I called her back or called Rob's phone again.
That's the defendant on the right there,
Um,
folks.
right away. And there was nobody who picked up. And that's when I guess I pulled over and decided to call 911.
I think he might have been wearing that whole tie, maybe that same tie and shirt the whole trial.
Now, based on your meeting or contact with Lauren Kanarek, did you get the impression that she wasn't afraid of Michael Barisone?
No, I got the impression she was very afraid of Michael.
Can you please turn to page 15? The 5th ed from the top. And see if that refreshes your recollection as to whether or not you got the impression that Lauren Kanarek was not afraid of Michael Barisone.
I'm on page 15. Please just direct me to where you want me to go.
1, 2, 3, 4, 5 eds from the top.
Oh, at that very moment, yes. I got you put that out of context. Lauren was afraid of Michael Barisone. At this particular period of time, after speaking with Mr. Tarshis and really making a significant headway in resolving this whole thing and de-escalating the situation, yeah, I think Lauren was not afraid of him at all. Not at that very moment, no.
Right before the shooting, correct?
Right before the shooting.
So again, as defense counsel, you ought not, all this lengthy witness explanation of context is something that you should place on the state to do on redirect with their witness. You're not obliged to let the witness go on these expository narratives like this when you're conducting cross-examination of them.
Because the whole thing was being resolved.
And maybe the state will forget to do that contextualization on redirect, in which case it doesn't get before the jury.
When you say the whole thing was going to be resolved,
Mhm.
you had never talked to Lauren Kanarek prior to the shooting with respect to your conversations with Tarshish regarding resolving this case, correct?
I don't recall.
Isn't it a fact that you called them on that day to apprise him of your conversation?
Now it's a
with
prize.
Tarshish?
I had called them on that day to apprise her of where we were at that particular moment in time. I had been on the phone with Tarshish since the day before, trying to resolve this.
Tarshish, I guess, must have been Michael Barisone's attorney for this tenant-landlord dispute.
Now, prior to this day, did you get the impression that the issues between Barisone and Kanarek had been going on for weeks, if not longer?
Did I have that impression? Yes.
Now, would you agree that what you were hearing traumatized you?
Yes.
And would you agree that that could have an impact on your recollection of events, correct?
No. Incorrect. The fact that I heard gunshots is immutable. I heard gunshots. The fact that Lauren said I've been shot in the chest is immutable. I heard that, and it happened. No amount of trauma is going to change that. There are things that, which you reminded me of, there were other things that happened that I now recollect, but I will never, ever forget that moment in time.
Why would you allow that kind of testimony on cross of the state's witness? This guy's just going to throw his forearm up on his head and lament the shooting of Lauren Kanarek. So I see in the chat that apparently the defense has begun its case in chief with some kind of police consultant, expert witness. When this is done, I'll hop over. I'll fast forward to that. It's somewhat hard to imagine what such an expert witness would be testifying about. Maybe, making the "I'm defending a criminal." Weren't there defects in the investigative procedure kind of argument? But we'll have to see. Then you don't see skilled defense counsel do this. This defense attorney, he buries himself in his notes midway through the cross, like he
You have the
doesn't
impression
already
that,
know what he wants to ask about.
Michael Barisone's girlfriend was creating issues with Kanarek and Barisone.
I was informed that that was the case prior to the shooting.
I have nothing further.
Oh, thank goodness.
Mr. Shellhorn, any redirect?
2 points, Your Honor.
2 points. I'll hang in there for the 2 points.
Thank you, Judge.
That's the prosecutor there.
Witness.
Oh my God, does he have the
Sure.
same tie as the defendant? That would be weird.
I don't know if it's an evidence.
What, he's offering something to the judge? What is it? Is it the pool for the golf masters?
Mr. David, for the record, that's been marked as S442. Directing your attention to lines 8, I believe it's lines 8 and 9. Do you see a
Okay.
phone number on those lines?
Yes,
And I'm not going to ask you to put your phone number on the record.
I would not do that.
But is that your phone number?
Yes, it is.
And does
my
that
cell phone.
indicate your cell phone? Does that indicate whether or not, and without telling us whether or not there was an incoming call or an outgoing call related to that number?
I'm sorry, without telling you whether it was an incoming or outgoing?
Just to look at it to refresh your memory.
Yes, it refreshes my memory.
Does that refresh your memory, or does that confirm to you whether or not you made the call to Mr. Goodwin or you received the call?
100%. I made that call. I made 2 calls, actually 3 calls.
So if the call came from the lawyer to Lauren Kanarek and Rob Goodwin, then for that all to have been theater for the purpose of entrapping Michael Barisone, this landlord-tenant civil lawyer would also have had to have been a co-conspirator to know to place that call for the purpose of the theater. That's different than if they had called him. If they had called him, if Lauren Kanarek and Robert Goodwin had called him, maybe they timed the making of that call to buttress their theatrics in framing Michael Barisone. But if the lawyer called them, unless you're willing to believe that this landlord-tenant lawyer, who'd apparently been retained by Lauren Kanarek's father only 24 hours earlier, was also a co-conspirator in this effort to frame Michael Barisone, which strikes me as quite the reach. The fact that he called them kind of negates that framing argument.
Which makes perfect sense.
And can you explain to the jury, and I'll just take this back, what your recollection is about the 3 calls that you made?
The first call, which appears to be 4 minutes, was my call to Rob to tell Lauren what's going on in the case and my discussions with Tarshis and when she got shot and whatever. The second call was after I disconnected the first call to see if she was okay. And my recollection is she didn't, or Rob didn't pick up. And then I did it again because, you just keep on calling until you're sure somebody picks up or you're sure somebody's not going to pick up. And I guess after that call, after the third call is when I called 911.
Now, you were asked a question about the handwritten notes that I think were marked as D1200D, when you had actually written those notes to yourself or written down what you recalled.
Yes.
And I think your answer on cross-examination was that you thought it might have been sometime in that first 24 hours or no more than 24 hours.
Yes.
I'm going to direct your attention, and I don't know if you still have it in front of you.
I
is the
have nothing.
transcript.
Yeah, I have nothing.
1200C?
Yes, Judge, 1200C.
Okay, thank
So
you.
I'm going
Honor.
to direct your attention, if you would, to page 21.
Yep.
Specifically on page 21, if you look approximately halfway down the page or so,
Yes.
where I believe that the detective asked, you were kind enough to give us a copy of your report,
Yes.
of your notes, rather.
Yes.
Does that refresh your memory at reading that about approximately when you wrote the notes down respective to the incident occurring?
Yes, and it jives with what I've been saying. I got back to my office, I wrote down the notes. It's my practice. I do it 100% of the time, not 99%, 100% of the time. I write down contemporaneous notes, scan them, and I believe throw out the original. This one I may have kept, I may not have. I don't have it. I don't know if I gave it to somebody from the prosecutor's office. I don't know.
And approximately how far after the incident occurring did you write those notes down to yourself?
Within an hour. I mean, right away. I signed it, I believe, when I met with the investigator.
Judge, no further questions.
All right. You may step down. Thank you, sir.
Thank you, Your Honor.
All right. And that's it
Should
for
I leave this here?
Yes, please. Thank
that
you, sir.
guy. And that actually gets me to
Mr.
the end of
Shellhorn?
my
Your Honor, subject to moving evidence, the state rests.
state rests.
Very good.
All right.
All right, ladies and gentlemen, the state has rested their case subject to moving in some evidence, which we're going to address right now during at least part of the lunch and recess. And then we'll begin the defense case in the afternoon. So enjoy your lunch. We're a little bit early, but you can take until 1:30 or so, and we'll hopefully have all the legal issues resolved, and we'll begin the defense case then. All right, thank you. Please don't discuss the case during your lunch and recess.
All right. So there's the lunch break. And I'll fast forward now to the past the lunch break, try to catch up a little more real time and get up to the, where are we? There we go.
In New Jersey.
Whoop.
Delay, we did have to address some legal issues, which have been taken care of. We'll now move on to the defense case. Mr. Belinkus, call your first witness, please.
Call Belinkus, of course, is the defense counsel here, the rather bizarre defense counsel. The state has rested. The defense is now presenting their case in chief and their first witness.
Joseph Blaitler to the stand, please. Please remain standing. Place your left hand on the Bible.
What's wrong with this tie?
Do you swear in the presence of Almighty God that the testimony given to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name and spell your last name for the record.
Joseph J. Blaitler, Blaettler.
Thank you.
All right, you may have a seat, sir. Please keep your voice up nice and loud. That microphone does not, it only records.
Yeah, unlike the
I
judge's
don't
microphone that
project the voice in the
captures
court,
every
also
pen
have to
click
keep
and
your
paper
voice up.
shuffle on the
If you
face
don't
of the earth.
understand a question, please indicate that, and I'll have counsel rephrase the question. All right, and if you hear an objection, stop answering until the court rules on the objection.
Understood.
All right, very good, sir. Mr. Belinkus, go ahead.
Thank you, Judge. Mr. Blaitler, where do you live?
I live in Morristown.
And what do you do for an occupation?
I'm a private investigator.
Do you have a company name?
Yes, East Coast Private Investigations in New Jersey.
Wow, very, very creative.
My background, I'm a retired deputy chief of police from the city of Union City. I was there for 23 years. After retiring, I became a private investigator / police consultant.
And who have you consulted for?
Numerous law firms, County of Suffolk, Georgetown Law Center,
And the name of your company is what, sir?
Oh my,
East Coast Private Investigations of New Jersey,
New Jersey
You know
PIs
Michael
Limited.
Barisone.
just by name.
And were you contacted at any point in a professional capacity by Michael Barisone?
Yes,
And when was that?
on or about July 31st of 2019.
And did he hire you? to
A
do
nice
something?
crack in the back wall
Yes.
there.
What did he hire you to do?
He asked me to conduct 2 background checks for him.
And can you tell me the names of the 2 people he had to do background checks on?
I believe one was Goodwin and the other one was, I don't know how to pronounce the name, begins with a K-A,
Kanarek?
Cataract.
Well, he prepared.
Right, and did you do a background check on both of those individuals?
Yes, I did.
And did you provide your background check to Mr. Barisone after you completed it?
Yes, I did.
I'm going to show you what's been marked Defense Exhibit 700A1 and ask you if you recognize this document.
These are the background checks I conducted. However, this one document I don't recognize.
Okay, well, then just take that out there if you would.
Yep, sorry.
So, I mean, if there was a basis for a self-defense argument here, that this PI had conducted a background check on Lauren Kanarek and Robert Goodwin, the victims of this defendant's use of force, and provided that background check report to Barisone before the shooting event, the knowledge of what's contained in that report would have been arguably relevant to Barisone's decision-making in self-defense, and therefore be admissible into evidence. Even though it's kind of background character information, because it's being introduced, it would be introduced not for the truth of the background record itself. It could be all lies, but for the purpose of the defendant's state of mind, whether the background check was accurate or true. If he believed it and it was reasonable for him to do that, then that would be information that would help form his decision-making in self-defense. So say, for example, the background check falsely claimed that Lauren Kanarek and Robert Goodwin had shot and killed the 3 last landlords they had. That may not be true. As far as I know, it's not true. But if it's in that report and Barisone read it and believed it, then that would help form his decision-making in self-defense. He may have a subjectively genuine and reasonably believed perception that he was facing an imminent deadly force threat from this couple.
And after you conducted your business, did you provide Michael Barisone with a copy of 700A1?
Yes, I did.
This defense attorney also does this funny My Cousin Vinny move where he asks the question and then he kind of struts away from the witness stand, so the witness is answering the question to his back, as if he's so confident in the question and the answer that he's going to get. Unfortunately, he's got the theater, but he doesn't have the actual performance. He doesn't get the similar outcome.
Did you have any other discussions with Michael Barisone?
I did have other discussions with him, but I really don't recall what they were.
Judge, I move in 700A1 into evidence.
The bailiff's checking his watch. When's that Jersey Mike's getting delivered? Oh, I guess the state objected. And there's the defendant looking creepy. By the way, he looked nothing like this at the event. His hair was cut normally. He just looked like a normal person when this went down. So he's acquired this crazy look since the shooting happened. So a quick, let's see, super chat. Tall Skinny Geek, thank you very much for your super chat contribution. Writes, I haven't been able to watch the case so far, but I can't even see the glow of the relevance over the horizon at night. This was the relevance of the cross-exam of that last witness who was the civil landlord-tenant lawyer for Lauren Kanarek in this case. And yeah, I mean, there was no relevance to most any of that. Arguably, perhaps despite the fantastic speculation about some kind of framing of Michael Barisone by engaging this lawyer on the phone, even though the lawyers who called them. And no, it's not witness intimidation to do an investigation of another party after whatever the event was. That's unless you try to use it to actually intimidate a witness or a party. I mean, that would be different. But simply being informed about that party's background, there's nothing inappropriate about that. Let's see, any more. On the Law Self-Defense Members Board, David is there. Hey, David, good to see you. Doesn't really post a question. He's just waving hello. Thanks for that, David. Refresh the Super Chat page. And I'm still all caught up. So don't forget our first free Law Self-Defense Hard to Convict webinar. These are free webinars. We have 5 of them scheduled over the month of April. Myth busting will transform you from being easy to convict to being hard to convict in less than a couple of hours. Totally free. Don't charge a penny. You can sign up for the webinars at lawselfdefense.com/hard to convict. I will tell you they're 65% full already. So each webinar is limited to 100 people. That's just so I can manage the Q&A that we do effectively for each webinar. And they're 65% full. So they're filling up fast. I've only been talking about them a couple days. Late last week, I think I started. So if you're interested in a seat, the first of these webinars is on Wednesday, April 6th. Again, you can sign up for that one or a later date in the month for free at lawofselfdefense.com/hard to convict. In fact, I think I have a slide for that, but I don't want to stop sharing this one for that one. Oh, I guess it doesn't hurt as long as they're not talking yet. Let me see. I'll pull that up. Here we go. So that's lawselfdefense.com/hard to convict for that myth busting webinar. Totally free. First one is Wednesday, April 6th. Then we have 4 more over the course of April. Again, it doesn't cost a penny, but limited to 100 seats each. They are filling up fast. Now I'll pull that back up. I think they're still doing their sidebar. Oh,
Go ahead, Mr. Malinkus.
it's the investigative report's not coming in.
And I do not want you to say anything specific. What does that background check look at?
Looks at people's previous residence, relatives, phone numbers, liens, judgments, bankruptcies, criminal histories.
So one possible ground for objection by the state might be, all right, he did this report and he gave it to his client, Michael Barisone. And in theory, the contents of that report could have helped contribute to Michael Barisone's subjective decision-making in purported self-defense. But one, there's been no actual evidence in support of self-defense yet. So self-defense has not yet met its burden of production. It's not in play. Or alternatively, there's no evidence that the client actually read the report. So it may have been mailed to him and sat sealed in the envelope on his desk, and he didn't actually know the contents. And if he didn't know the contents, it could not have informed his decision-making in purported self-defense. And folks, when you're trying to document that you had some knowledge at the time of an event, you don't need a lot of evidence that you possess that knowledge, but you need more than 0 evidence. And where would even 0.1 evidence come from that Barisone had possession of this knowledge at the time that he'd actually read the report? I can think of no other source than Michael Barisone. And he's not taken the witness stand to say he's read that report. So those are all possible grounds why this investigative report's not being admitted.
It's, employment comes up sometimes.
Okay, I have nothing further.
Oh, that was it. No wonder.
Cross-examination?
Briefly, Judge. Mr. Blaitler, you never met Robert Goodwin?
No.
And you never met Lauren Kanarek?
No.
And you didn't confirm or corroborate any of the information that showed up in the background check?
No.
And you told Mr. Barisone certain methods that he could do to verify these things if you wanted to?
Yes, if you wish to follow up.
Thank you, sir. No further questions, Judge.
All right,
Oh,
you
that-
may step down, sir.
That was quick.
I'm sorry, Mr. Malinkus, any redirect?
No, sir.
You may step down.
Oh my God. So the entire point of that cross was to get that investigative report into evidence so that the jury would have it with them in during deliberations. And it completely blew up in defense counsel's face. He did the cross. There was nothing damaging to the state's narrative of guilt in it. There was nothing to support an argument of self-defense or insanity or impairment on the part of diminished capacity on the part of his client. There was nothing there helpful to the defense or harmful to the state. Maybe there was in the report, but then the judge rules it inadmissible. That was all nonsense. That's why when the report was rejected as inadmissible as evidence, it all ended. Good Lord. What a waste of time. What a waste of effort in hiring that PI, getting him on the witness stand.
Down. Thank you, sir.
Thank you, Mr. Blaitler. Defense calls Larry Davison.
Mr. Davidson,
Get her done. I see in the comments here, this defense is flying through their witnesses. They're on their third one, apparently, at the moment. We're watching
Mr.
a
Davidson,
delayed.
please remain standing
Ooh.
for a moment, if you would, please. Place your left hand on that Bible. Raise your right hand. Listen to my court clerk, please.
He knows the
Swear in
best
presence
bridges
of
to sleep
Almighty God
under.
that The testimony you give to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth. Please state
No,
your name
not
and
only
spell
no
your
tie,
last
no
name.
hairbrush.
Lawrence Davidson, DAVIDSON.
Thank you.
All right, you may have a seat, sir. Please keep your voice up nice and loud.
Oh
That
my
microphone
gosh.
only records it. It does not project your voice in the courtroom.
Defense
So you
counsel
have to
couldn't
keep
get
your
this
voice
guy a
up. If you
haircut
don't understand the
before calling him
question,
as a
please
witness?
indicate that. I'll have counsel rephrase. If you hear any counsel object, please stop answering until the.
I mean, the
court resolves
defense
that
counsel's got
objection.
plenty of
Go
hair. He
ahead, Mr.
couldn't
Barnes.
couldn't do a loner.
Mr. Davidson, where do you live?
Glen Gardner, New Jersey.
And can you
Which
tell the
bridge?
ladies and gentlemen of the jury what you do for a living?
I drive a truck.
And who do you work for specifically?
Robert Jenkins is a nurser.
And what do you specifically do for them? Just drive?
Haul trees.
Okay.
He's a tree hauler.
You know my client, Michael Barisone.
Yes, I do.
How long have you known him? I see a smile on your face.
Is this a character
How long
witness?
have you known him?
Probably 20 years anyway.
Okay, and how do you know him?
I've known him from the farm. I worked for him, brought hay in for him and stuff like that.
Okay. Did there come a time in August of 2019 where Michael Barisone hired you to do something other than haul hay or deliver things from the nursery?
Yes.
What did he hire you to do?
He asked me to watch the barn.
And when you say watch the barn,
Yeah.
what were you watching it for?
Well, he was having problems with the girl that was in the house.
And
I don't even know her name or anything.
in hiring you, did he express concerns about her?
Yes,
And is that specifically why he asked you to come there?
yes.
And what time would you come during the day?
Probably like 8 o'clock at night. I wouldn't be there during the day, just at nighttime.
Okay, and what time did you leave?
Like 6 o'clock in the morning. I had coffee with Mike and trying to talk to him, but he was so,
If that hair starts
I
moving,
don't know, just so
I'm gonna
messed up
freak
that
out.
He couldn't even hardly talk.
All right, so do you recall the first time you came to the property on a particular night?
would you agree or disagree that your
Oh, first
sister is a
time?
Medusa?
Yeah, I was driving up there and the girl comes out of the house, comes running out of the house and says, "Who are you? Who are you? Who are you?" I just kept on going. And I got up to the farm and I saw Mike and then sat there for maybe 10 minutes and 2 cars come up the driveway.
And
And I said, "Oh boy."
Oh
At
boy.
some point in time, did those?
That's what we said, dude. When you came into the courtroom.
Well, yeah, one went around the barn and one pulled up by me. And they were police. So they were on marked cars. I didn't know who they were.
And did you have a discussion with the police?
Just all he said was, how's everything? I said, it's quiet right now. And that was it. And he left.
And did they ask you what you were doing there or why you were hired by Michael Barisone?
No, nothing.
Now, so I'm not sure if you told us the first day that you came there where this incident happened. Was that August 1st?
I believe so, yes.
Okay, and did you come there each night thereafter to the day of the incident?
Yes.
And each night, what
The
what
judge
was
is
your-
scribbling again.
What was your like?
I swear to God, if I find out he's
Just
been
to park
writing
by the
dear
barn, make sure
dear
nobody gets
tiger
involved.
letters to Tiger Woods
And
to
during that
convince him to
week
play in this
leading up to the
Masters.
shooting, did you have occasion to see Michael Barisone?
I seen Mike every night, yep. He constantly was walking the property, constantly walking the property.
You mean after hours?
Yeah, all night. All night he was walking the property.
And did you have an opportunity to observe him physically, like his physical appearance?
Well, say what you will about his hair,
Yes.
but Jada Pinkett Smith
He was-
is looking on
I don't know,
fondly.
He was just terrible.
Enviously.
He just couldn't, he was beside himself,
And you've known him for how long?
like 20 years.
Have you ever seen him anywhere near in this condition during that 20-year period?
Never.
And with regards to your observation, what specifically did you observe about his physical appearance?
He was just distraught. He was, I mean, he could hardly talk. He could hardly talk.
Did
We
you-
used to have coffee in the morning. He'd be sitting at the desk there and I'm trying to talk to him and he was just, he was out of it. He was out of it.
Imagine we find out he's like the
now, you said
2022
you observed him
world champion hair comb over
Every night-
winner.
every night I was there.
he's
What hours every
actually
night?
in the
Well, I
competitive
got
comb
there like
over
8 or 9 o'clock
sport.
and he was up all night.
He's got a wall full of
He'd come
trophies
out,
at
see
home.
me, and then he'd go back, back around again and be on the porch, then come back out again.
And how many times would he do this on each night?
Probably 3 or 4 times a night. Come out, by me.
Did you notice anything in the way he was dressing that was different than you had previously observed prior to these?
No.
I have nothing further, Judge.
Mr. Shellhorn, any cross-examination?
Just briefly, Judge.
Go ahead.
Mr. Davis, good afternoon.
I don't.
Do you remember being interviewed by members of the prosecutor's office on October 2nd, 2020?
I'm back.
Where was that at?
Did they meet you at the Hunterdon County
Hospital?
Medical Center?
Yeah.
Do you remember that interview?
Yes.
You probably talked to them for about an hour that day?
Yeah.
And you didn't mention anything to them during the course of that interview about anyone running out of the house or trying to flag you down?
I don't know. Maybe I did. I don't know. We didn't talk about that.
You would agree with me that during the time that you were there at the farm on the overnights, no one ever tried to come and enter the barn during the times you were there?
No, the only guy that came up and, surprised me was Mike. He come walking up by the truck. Okay, Mike.
Nothing further, Your Honor. Thank you.
All right, any redirect?
No, Judge.
All right, you may step down, sir. Thank you, Mr. Davidson.
And may God have mercy on your comb. Okay, let's see where we are now. Oh, right away.
Christiana Cook Gibbs, COOKE-GIBBS.
All right, Ms. Cook Gibbs, you may have a seat. Please keep your voice up nice and loud.
Thank you.
Like that microphone does not
Coob-
project your voice
Coob
into the
Gibbs.
board, so you have to speak
That's
loudly.
that's
If
an
you don't understand the
unfortunate
question, please indicate.
hyphenation.
Go ahead, Mr. Malinkus.
Thank you, Judge. Ms. Gibbs, where do you live?
I live in Alamucci, New Jersey.
And who are you employed by?
I'm employed by the Township of Washington in Morris County.
And can you briefly describe your background?
I have a Bachelor's of Science degree in Animal Science. I have my Master's in Public Health.
Okay, who do you currently work for?
Washington Township, Morris County.
And what's your specific position for that?
My specific title is I'm the health officer for the Health Department of Washington Township.
And how long have you been doing that?
I've been employed by Washington Township for 36 years.
Oh my gosh.
And what does that entail?
Typical New Jersey.
Job description.
Being a rural community,
But
the
I'm-
bulk
I'm-
of my position was
on the
I'm
taxpayers'
charged
backs
with
for 36
administrating,
years.
Administering laws that protect public health, both municipal and state. A lot of my job involves environmental work, septics and wells. We do everything from
What's your
rabies to
name?
food inspections.
Christiana, but
last
everyone
2 years,
calls me
COVID.
Karen.
Okay.
That's
Uh,
all caps. Karen.
Did you have an occasion to respond to my client, Michael Barisone's property on August 6th?
I did.
And before we get to that, prior to that day, did you know Michael Barisone?
I did.
And how did you know him?
Through dealings with the property. The property was a farm, and at some point in the late 1990s, it was developed into a dressage facility, and a large equestrian center was built. And I was involved with the permitting of both the front home that was moved and made into a double home, and then the equestrian center in the back. So well and septic permits I was involved with from the beginning of the development of the property. And then somewhere, Michael wasn't my primary contact with the property, but eventually Michael turned out to be my point person there. And I remember there was a septic problem in about 10 years in, and we had to rebuild the septic. And at that point, Michael was the point person for the property.
Okay, so prior to the 6th, over the years, you've had an opportunity to come in contact with Michael and observe him in normal day affairs, correct?
Yes, sir.
And how would you describe him in those days?
Very competent, very dignified, elegant man, you know.
Do you see him in the courtroom today?
On the 6th.
No, I don't recognize him.
Do
So
you
that was
know, who signed
that
it?
was a bit of theater by the defense. So we have the defendant here acting all kind of crazy and grimacing, weird facial gestures, moving his head around rapidly, hunched over, this long shaggy hair, disheveled looking. This is not how he looked in normal life prior to these events. This is how he looked since the event, I guess. And of course, it's always a question whether or not he's presenting this way in court as a charade, or if this is a true reflection of a emotionally and psychologically broken man. I'm not really sure how that's relevant, but unless you're going for the impaired decision making, diminished capacity defense, or just the sympathy hope from the jury. But the prosecutor asked defense counsel here asked their witness, this woman, about how she perceived the defendant's demeanor and appearance in the past. And I guess he had himself put together. And then the defense counsel just glances over at his client, and you see this hot mess sitting there.
I want to ask some foundational questions.
Thing from rabies to food inspections, last 2 years, COVID.
Okay. And how long have you been doing that?
I've been employed by Washington Township for 30,
Okay.
and at some point.
Went back a little
in
too
the
far.
late
Sorry, folks.
1990s, it was developed into a dressage.
In those days?
Very competent,
Here
very
it is.
dignified, elegant man, you know.
And that hot mess that
I'm
is my
six.
client.
Do you know who signed the complaint against Michael Barisone that caused you to go to the property?
Well, have we established that? I want to ask some foundational questions.
Again, these
Why
are
did
just
you go to the
mistakes you don't
property?
make as a competent attorney.
I went to the property because a complaint was received by another department in the township. The construction department received a complaint alleging that unpermitted work had happened at the property. And ancillary to that, it would have involved my department. There was allegations that an apartment was constructed in the barn, and therefore it would have impacted my authority. And
How does that impact your authority, an apartment in the barn?
because the septic system for the barn was only sized to accommodate a certain amount of flow. Septics are designed for
Flow.
gallons, and that septic was only designed for a very specific purpose and not to accommodate living space.
Okay, and prior to going to the property, did you ascertain who made the complaint?
I don't recall, the complaint was not made directly to me. I did not have any.
I believe
interaction
Lauren
with the complainant
Kanarek
before
testified
allowing
that
the
she was the one calling in these complaints
Now, when you said you
to
went on the
to
property,
just cause
did
problems for Michael
anyone else go
Barisone.
with you?
I specifically drove to the property with my colleague from the health department, but we met there at the same time with representatives of the construction department and the fire official.
So
we all
Lauren
can
Kanarek called
convene on the
everybody
property at the same time in different
on
vehicles.
Michael Barisone.
And how many vehicles converged on the property
There
at
could,
that time?
there would have been at least 3 vehicles, maybe 4, but at least 3.
Okay, and at some point in time, did you have an opportunity to observe Michael Barisone?
Yes, I did.
And did you observe him before you and the other town officials started doing your job, so to speak, walking around and looking at things?
We originally arrived to the property and got out of the cars at the house in the front, the 2-family house. Took a look around, didn't appear that anyone was there. We knocked on the doors. No one was there. So we were getting in the cars to go back. The barn is quite a distance off the road. And then the gentleman who I found out who was the complainant arrived, spoke to the construction official.
Robert
I
Goodwin?
backed away from the conversation. I wasn't part of it.
And again, when you say the person that made the complaint, who was that?
I believe his name was Robert, but I don't particularly
Yep.
remember his last name.
Goodwin?
Yes,
Now, you indicated that when Robert Goodwin started talking to the construction officials, you backed away.
I did.
Why did you do that?
I just didn't get a good feeling about, he didn't complain to me. He didn't reach out to me, and I I literally backed away.
Did there come a time when you went up towards the stable area, the barn area?
Yes, we did. We all got in our cars and we proceeded up to the stable.
And at that point, did you have an opportunity to see Michael Barisone?
I did. He and Mr. Lundberg, who was the gentleman who I had originally dealt with on the property from the beginning, were outside sitting on the porch, I recall. And Mr. Lundberg got up and came and greeted me. And I then walked back with Mr. Lundberg, and we spoke with Michael at the time to let him know why we were there.
Okay. And you mentioned the name Lundberg and someone that you had dealt with. Is he Michael's partner in that stable, as far as you know?
I don't know what the official relationship was between Mr. Barisone and Mr. Lundberg, but I assume it was a business arrangement and a mutual passion for what they were doing there.
Now, do you recall when you first observed Michael Barisone on that day?
I do.
And can you tell the ladies and gentlemen of the jury what your impressions were when you first saw him?
He was very distraught, very disheveled, very, very upset.
Can you describe his physical appearance?
Unlike my prior meetings with him, he was very, very, very different. He was, sweating and pacing and mumbling.
Did he appear to have bathed recently?
It's a little
Don't
personal.
remember. I couldn't get that specific, but it was
The bathing
much
question.
different than any prior meeting that I had had with him.
Would shocking be a reasonable term?
It was very just,
Objection.
That's a little leading, Mr. Malinkas. Sustained.
So, of course, right up till now, the defense has been conducting cross-examination of the state's witnesses. So leading questions are permissible on cross. But now, finally, the defense is presenting its own case in chief. These witnesses are defense witnesses, and you can't lead your own witnesses absent some declaration that they've become a hostile witness in some respect, which clearly she is not. But just like this, defense counsel appears not to know what hearsay is when he was conducting cross. I'm not sure he knows what a leading question is. I guess we'll have to find out.
How would you describe your observations?
And a leading question, of course, is a question that suggests the answer to the witness. For example, the car you saw go through the intersection, was it red? Well, you're suggesting that it was red. More appropriate would be, what color was the car that went through the intersection? And let the witness come up with the answer.
Previously, with the observations on August 6th,
a very different person.
in what way?
He was disheveled.
Just say agree
He
or disagree
was
to
upset.
get around
He-
leading.
he
Was that Kim Potter's trial?
undone. He wasn't the competent.
It was. No, it was
that I remember.
the Curtis Reed's
And,
trial.
Very, he made comments about being fearful.
Objection, Judge.
It's hearsay.
Yes,
Non-responsive and it's
sustained.
hearsay.
That's hearsay.
You can only describe what you.
Okay.
Your observations of Mr. Barisone, as you've done,
I'm
but
sorry.
nothing that was said.
Okay.
That would be hearsay.
Anything else that pops into your mind regarding your observations of him?
No,
What was your impression of him based on your observations?
he was very, very distraught and very, very different.
Nothing further.
So none of that is going to be relevant to a claim of self-defense as a legal defense, or really, it doesn't come close to approaching anything like an insanity defense. It may be relevant to a diminished capacity defense or an imperfect self-defense, where the belief in the need to shoot Lauren Kanarek was genuine, but unreasonable. Or just a wishful hope for the jury to be sufficiently sympathetic to this defendant, given the torturous treatment he received at the hands of the victims here, that they would acquit or compromise on some lesser included offense other than attempted murder. That's the only apparent purpose for her testimony. Let's see if the state does any cross here.
Cross-examination?
Ms. Cook Gibbs, had you ever met the individual that you referred to as Robert Goodwin before that day?
I had not.
And did you feel like after meeting him that he didn't fit there?
Objection.
What's the basis for the objection?
Let's.
Your impression of whether he fit there? I don't even know.
What she said.
Yeah,
Oh, the balls on this guy. This defense attorney has been asking questions through the whole trial where it was impossible to understand what it was he was getting at or asking. He's had to be repeatedly corrected. And now there's maybe a faint scent that this question from the prosecutor is perhaps more ambiguous than it ought to be. And he immediately jumps up and objects. Good Lord, does this lawyer not have a mirror?
I mean, you had her describe what she did when she met him.
It's so funny. I mean, yes, you're right in the comments. I love it when they do that. The lawyer like objection and then just kind of waves his hands like, Your Honor, please don't ask me for an explanation.
And that seems to be
Follow
follow-up by the state. Overruled.
Mr. Good.
Do you recall when you were interviewed by members of the Washington Township Police Department on September 17th of 2019?
I honestly didn't remember it until I got subpoenaed. but now I do remember being interviewed. It was a long time ago.
Do you recall telling them that you felt like Mr. Goodwin didn't fit there?
I did. I do.
You showed, or you and the other township officials came to the property on August 6th unannounced?
We did. I mean, I don't know if the construction department announced. I went there unannounced. I can speak for myself only.
Meaning the health department did not notify anyone that they were coming?
That's correct.
Had
And
you ever observed Mr. Barisone during a training session?
actually, yes. I was on the property once to watch a horse, and I believe Mr. Barisone was there.
What was his demeanor during the course of that training session?
Very professional.
Now, you responded on August 6th to investigate potential health issues or environmental issues?
That's correct.
And did you identify health issues and environmental issues?
I observed work that was done without permits that would have required the health department.
Ironically enough, the work
I
was being
did,
done by one of the victims here,
an
by the Robert Goodwin, who would
environmental
call
issue
to
and
complain
result of
about the
it,
lack of
no.
permits.
But, you know, I didn't observe a malfunctioning septic or something like that, but I did observe work that should have been permitted and should have been reviewed and authorized before it was done.
For example, that the septic system would have been overloaded by the number of bathrooms or something
Right.
of that nature,
Right, which could have led to a problem down the road.
if it wasn't located and identified by you on August 6th.
Yes.
No further questions, Judge.
Just one more from me.
Redirect.
Can you explain why you didn't feel like the Robert Goodwin didn't fit in there when you never really met him before?
I just got a bad feeling. I don't know why.
Nothing further.
All right, you may step down, ma'am. Thank you very much.
Thank you.
2000.
Oh, darn it.
Approximately construction.
Okay, sorry, folks. I accidentally hit the wrong thing. Let me. Okay, there's that guy, this guy, the woman.
Vehicles, maybe.
Sorry, folks.
What she said.
You can only
Much.
Thank you.
Okay, caught up. Sorry about that.
All right, Mr. Malinkas, call your next witness.
So this defense attorney was Balinkas was purportedly a federal prosecutor and then spent some 30 years doing criminal trial law, which is almost impossible for me to believe. I mean, it's common for prosecutors in general to frankly be less capable than their defense counsel opponents because they generally have an easier job. Most of the cases they're bringing to trial, the defendant is guilty. And it's not that hard to demonstrate beyond a reasonable doubt. So they just don't have to be as sharp as the defense attorney who's working at a comparative, very profound and substantive disadvantage. They're trying to defend a guilty person, a really guilty person, a demonstrably guilty person. So it's very common for the defense counsel to have to be sharper as lawyers than prosecutors. I don't know to what extent that plays a role here, but there we are.
Bill Herwagen.
All right, Mr. Bill Herwagen.
Bill Herwagen. A lot of curious last names here.
Hello, sir. Please remain standing. Place your left hand on that Bible and just turn this way. Face my law clerk. She'll administer an oath. My court clerk, excuse me.
Do you swear in the presence of Almighty God that the testimony you give to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name and spell your last name for the record.
William Herwagen Jr., Heerwaggen.
Thank you.
All right, very good, sir. Have a seat. Please keep your voice up nice and loud. If you don't understand a question from counsel, please indicate that. I'll have them rephrase. Go ahead, Mr. Blankus.
Good afternoon, Mr. Herwagen.
Afternoon.
Oh my God, this guy looks terrified.
I live in Washington Township, Warren County.
And what do you do? for
It's
a
like he
living?
was just approached by police wearing a trench, and he's wearing a trench coat
Currently,
outside a
I'm licensed
playground.
Instructor for surgery centers. I'm a retired firefighter.
Okay, back in August, specifically August 6, 2019, what did you do?
I was the fire inspector for Washington Township, Morris County.
And can you give the ladies and gentlemen of the jury a little bit of your background?
Folks, if you're a witness and you don't want to
Working
swear
with
on a
Washington
Bible, they
Township.
won't make you take an oath on a
Well,
Bible.
previous
Instead, you can do what's called an
employee
affirmation,
had
which is
uh,
religious free.
what you were there.
I was I'm a retired firefighter, fire captain from Maplewood, New Jersey. I am also was a fire marshal for Washington Township, Warren County, Washington Township, Morris County, and several other towns, Independence and Mansfield.
Okay, and back in August of 2019, did you have an occasion to respond to my client, Michael?
It's a good question. Does this defense attorney think he's doing a good job himself?
Why did you
Well,
respond?
Dunning-Kruger would
Was at the
suggest
request of
the answer is yes.
Fire marshal.
He may well think
at
that.
the time. He asked me to take a ride with him to issue violations.
And to your knowledge, was a complaint filed?
At that time, I wasn't aware of anything, no.
So basically, you're just asked to come along for the ride,
Right,
correct?
correct.
And prior to that date, had you had occasion to see Michael Barisone before?
No, not at all.
So on the 6th, that was the first time that you ever laid eyes on Michael Barisone, correct?
That's correct.
And can you describe his demeanor when you first saw him?
When we arrived, he approached us and there was a short dialogue and he seemed very upset to the point where he actually started sobbing.
Actual sobbing? More than crying?
Crying. I use the word sobbing as far as crying.
Did you ever determine why he was crying and what issues he had?
Give him a hug, smooth his hair.
Later on,
I'm going to object on speculation, Judge.
Let me
What?
see that sidebar.
I don't know. He can ask. Why can't he ask? If he asked and he got an answer, he could say, yes, I got an answer. I mean, probably can't. I mean, arguably the answer would be hearsay if it was admitted for the truth of the statement. Another sidebar. Hey, folks, I want to thank everybody for putting us over 30,000 subscribers on YouTube last week. But for those of you who may not yet be subscribers, if you could pound that subscribe button good and hard. By the way, if you subscribed in the past, you might want to hit it again because I'm told that sometimes YouTube just arbitrarily unsubscribes people. So hit the button to make sure you're subscribed. Hit the bell. Make sure you've done what you can to get notifications. I mean, YouTube is sketchy about such things, as we all know. Hit the like, thumbs up button. Leave a comment, even if it's only your city and state. That helps fool the YouTube algorithm into giving law of self-defense more love than YouTube would otherwise be inclined to give. So that's all of that is always appreciated. And let's see, I'll check the super chats as long as we're on another pause, as well as the questions. Let's see. On the Law Self-Defense members page, Mike Dog has made a reference to, I'm pretty sure posi traction wasn't available on the 64 Buick Skylark. I don't think she was pretty sure. I think she was sure.
Mr. Malinkus, you can rephrase if you wish to.
Sure. Mr. Herwagen,
Yeah, the
in
state.
regards to these code violations, did you and your
He didn't rephrase. He moved on to another question.
boss or colleague
I saw it in the comments, but the state
determine,
wins every sidebar
who
here.
was doing the construction at the facility?
That was more on my boss's part.
Okay. All right, I have nothing further. Thank you.
Any cross-examination of Mr. Herwagen?
Briefly, Judge. Mr. Herwagen, do you know if the visit to the property was announced to Mr. Barisone before you went there?
No, I was not aware if it was or not. I know it was a second visit to the property where my boss supervisor was there earlier in the day, where he, I guess he viewed what was supposed to have been written up. And he went back later that afternoon to issue the construction violations.
And when you talk about that individual, is that Mr. Lopez?
That's correct.
Who else was at the property when you were there from the township?
Neo Juro, he was the construction official at the time.
Do you recall if Ms. Cook-Gibbs was there at that time?
No,
When
she
you were
was
there?
not. I know she wasn't there at the time. It was just the three of us.
And you indicated that you had gone there in your capacity related to the fire inspection?
I was asked to go along as a second party. He was issuing violations and he felt that it was best to have somebody with him.
And there were actual fire violations located at the property?
I believe so. I did not see exactly what they were. Mr. Lopez would be more aware of what exactly he wrote up. I didn't write it up.
No further questions, Judge.
All right, quick
Any
work.
Fine, you may step down, Mr. Herwagen. Thank you, sir. Call your next witness, sir.
Matthew Lopez.
Matthew
Yes,
Lopez,
Mr. Matthew Lopez.
another
please.
inspector. Because they called everybody. Robert Goodwin and Lauren
Mr. Lopez,
Kanarek called
please,
everybody. Yeah.
Remain standing for a
Another
minute. Left
inspector.
hand on the Bible. Raise your right hand. Please listen to my court.
Do you swear in the presence of Almighty God that the testimony given to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
I will.
Please state your name and spell your last name for the record.
Matthew Lopez, Lopez.
Another interesting
Fine,
hairstyle.
you may have a seat, sir. Please keep your voice up.
Oh,
That microphone only records. It doesn't project your voice in the courtroom, so keep your voice up so everyone can hear. If you don't understand a question, please indicate that. I'll have counsel rephrase. Very good. Mr. Malinkus, go ahead.
Mr. Lopez, what do you do for a living?
I'm a fire inspector.
yeah. Okay.
And for-
So I don't know. I don't see how this testimony is going to be any different than the last
Can you hear
inspectors.
okay? Sort of. I see it, leaning forward a little bit. Try to keep, and there's a hand back there. Yeah, I thought that. Just keep your voice up nice and loud.
You're
Go
a
ahead.
A fire inspector for Washington Township?
Correct.
And how long you been doing that?
About 10 years.
And what training or experience you they
It's like they don't have any witnesses
I
to
have a
call.
Fire inspector, fire official certification through the state.
They just,
And you've been doing that for 10 years?
it was the defendant, Michael Barisone. It was the victims, Lauren Kanarek and Robert Goodwin. And it was Lauren Kanarek's lawyer
Did you respond to my
on the phone, an
client's,
ear witness of sorts.
farm in Washington Township?
Who's the defense going to call? Except all these inspectors to say, hey, weren't you called by Robert Goodwin to support this whatever narrative that Lauren Kanarek and Robert Goodwin were mean to Michael Barisone, which I believe. I believe they were monstrous to him, but that doesn't justify him shooting them.
And ask you if you recognize that document.
Maybe the
recognize
horses
that.
are next.
And is that the reason why you decided to go out there on the 6th?
That's correct.
Now, prior to going out, did you talk to anybody about that complaint?
We received the complaint and we decided to
I
go
mean,
out to
If this
investigate the
was
next day.
being done in a foreign language we didn't understand, like, I don't understand German. If
People
this was
signed
being done in
that
German by
complaint,
this defense
correct?
lawyer's demeanor, I would think he
That's
was
correct.
making a point.
And prior to going out, did you attempt to contact those people?
Unfortunately, it's being done in
to
English
try
in
to
front
see
of an
what you
English
were
jury.
dealing with?
We did not.
Okay, so does that complaint accurately?
Oh, the dog. The dog was also a witness. So I guess maybe the dog
the
could be called
reasons
as a
why you
hostile
went out
witness
on that particular day?
by the defense.
Yes, it stated fire code violations were at the property.
Okay, Judge, I move D100E2 into evidence.
But was anything actually on fire?
I would object, Judge.
What's the basis for the objection?
Same objection that I had with the prior document. I think this is hearsay.
It's not offered for the truth.
Why is it being
was offered for
offered?
the truth. Let me see it. Let me sidebar, please.
So when they come back, if the report's gone, that means the state won on this sidebar again. If the defense just moves on to some other question. Yeah. Yeah. Well, some of the comments says, show me a stable that's in compliance in fire code. In my experience, show me almost any structure or dwelling that's actually in compliance with fire code. Maybe the instant after the final inspection before it's formally occupied, maybe it's in compliance then. Once it's been occupied for any period of time, good luck. It's more those the codes are, in my experience, are more aspirational than fully complied with. I can't. I do a lengthy summary of the trial and the facts and the charges and the defenses at the start of each of these shows, folks. But this is just a sidebar. I can't do it in the limited time that we're likely to have available. If it was a break and we were watching live, I would cover it again for those of you coming in late. But we've been contrary to Nick Recada's usual practice of watching it live moment to moment. We've been scrolling through the live broadcast with some delay. So we haven't really had many breaks per se. I've just skipped past them until we're pretty much caught up. I think we're only about 15 or 20 minutes behind the live feed at this point. Yeah, about 18 minutes or so. So yeah, this is the judge getting tired listening to the defense at sidebar. He's going to rule in favor of the state. The defense will come back and move on to some other line of questioning, not having to do with that report. The charges are attempted murder, 2 counts of attempted murder, which would normally be sentenced just like murder. You don't normally get a sentencing break because you
All right,
failed
rephrase your question, Mr.
in your
Belinkis.
attempt.
Mr. Lopez, in the complaint,
I'm going to object to that, Judge.
Yeah, just, it's your witness, Mr. Belinkis. You can ask him what he did without getting into the specifics.
He doesn't know how. He's stumped. Look at him.
with regards to the farmhouse, specifically the basement area, did you go and check down there to determine whether there were any violations?
Yes, we went down to the basement.
And what were you checking for
We were looking.
down in the basement?
We were looking for fire code violations. We were looking to see if anyone was staying down there and if there was any other violations such as, open wiring and missing fire protection devices.
And were people staying down there?
There was nobody there when we were there.
Now, you checked the rest of the house, correct?
That is correct.
And based on your inspection, did you issue violations?
Yes, we did.
What specifically did you issue?
We issued a imminent hazard for the house.
Yeah, I believe Barisone was offered a plea of 10 years.
Let's talk about the house.
And based on what I've seen here, he definitely
What
should
were
have
the
taken it.
issues with the house?
The house had 0 smoke, hardwired smoke alarms. They were all missing from the ceiling. And then there was open wiring.
Imagine what the
throughout
fire
building,
code looks like in
missing
New
fire,
Jersey.
Rated construction from the 1st and 2nd floor.
Probably have to label each electron.
I'm sorry, what did you say about the first and second floor? I didn't catch that.
There was missing fire rated construction. The ceiling was missing from the 1st floor to the 2nd floor.
Okay. And based on those observations, did you issue a violation?
Yes.
And what's the result of you issuing a violation? What are the consequences, so to speak?
The owner or operator of the property would have to abate the violations within the time frame the code allowed.
And is someone obligated to move out and remain out of the residence until those specific issues are addressed?
With an imminent hazard, nobody is to go back into the property unless it is to abate the imminent hazard.
So the defense has been arguing, they did an opening, that essentially what Lauren Kanarek and her boyfriend Robert Goodwin did by filing these complaints was make Michael Barisone homeless because he would be kicked out of his home because of these code violations. Now he was living on the front porch of the barn or something like that, a mattress on the front porch. I mean, okay, maybe the worst read on that for the state is that these two victims were absolutely horrible people that did this reporting completely out of malice, maybe for the specific intent of having Michael Barisone have to live on a mattress on the front porch of his barn. None of that provides a justification for shooting him.
Right. I've seen pictures of violations posted on the back door. Did you post those?
I did. Nobody was at the property.
Yeah, and by the way, when I mentioned he should have taken a plea, he was offered a 10-year plea. He's also facing a gun charge in New Jersey because, well, it's New Jersey. So, of course, he's facing a gun charge. He was not in lawful possession of the gun. That gun charge under New Jersey law might by itself be good for 10 years. So when I say 10 years would be a gift on these facts, it includes that gun charge as well. There you go.
At the house when the violations were issued. So I posted it on the building. So anybody that came back saw the violations and were aware.
Right now,
By not taking the plea, normally intentional murder is good for life in prison without possibility of early release, absent some kind of mitigation. Of course, here there'd be aggravation because he used a gun to commit the murder, and I'm certain, without having actually looked, I'm highly confident that New Jersey would impose a sentencing enhancement for committing a murder with a gun. So he'd be looking at life plus without possibility of early release. And normally attempt is sentenced much the same as the underlying offense. So attempted murder would be sentenced much like murder. You're not given a break for having failed in your attempt. So, I mean, yeah, he's looking at something like life plus whatever the gun sentencing enhancement would be when he could have had 10.
would you strike that? What does the violation say are the consequences to anyone who ignores those violations and goes in and resides in the residence?
There's fines involved with that.
Up to $5,000?
Correct.
And who's the owner of that property based on your investigation?
I had Sweetgrass Farms and Barisone Dressage as the owner operator.
And that's Michael Barisone's company, you know, correct?
Yes.
Now, so I understand the sequence of events. You place a violation on the door of the farmhouse, correct?
Yes.
And there's another stack of papers posted also. What is that?
I'm not sure which
Why
one.
don't you
that
show
is.
him the photograph? If you have it.
This judge must
Well,
be so
when you make
tired.
your
What?
determination that there's a violation and that people must leave, what do you post on the doors?
Post the notice of violation after I've issued it to the property owner.
So it's what? It's about 3:30 New Jersey time right now. Look at that defendant.
So at some point.
I
in
think
time,
he's
you
wearing
go
the
to
same
state
tie as the
level,
prosecutor
correct?
today.
Correct.
And did you,
Maybe it's like a low budget
Similar
student
type of
film and they're
violation
swapping the tie back and
on that
forth for
front.
different scenes.
I don't believe I did.
I mean, do you ever see the prosecutor and
delivered it
defendant in the
to,
same frame at once?
Uh,
Not me.
Mr. Barisone.
and when you say you hand delivered it to who, my client? Michael
Correct.
Barisone?
Yes.
Sorry, when I said it's 3:30 in New Jersey, I'm meaning obviously the real time is
Was
3
he
o'clock. I mean, in
basically,
terms of
based
this
on
video,
your-
because we're about 20
your
minutes behind on the
inspection,
video.
Not allowed to re-enter the property and sleep there?
No, nobody can stay there until the imminent hazard has been abated.
Can we clarify which property you're speaking about?
I'm talking, I thought I did the stable area. I show you D 800/81.
If the defendant were acquitted on grounds of insanity, he would not go to prison. He would not
And
have
ask
criminal liability, but
If
he would
you
be
know what
institutionalized
those
for some
pieces of
indefinite
paper
term
taped
until
in the
his
back
doctors
door are.
decided he was not a threat to society.
The one is my imminent hazard. I'm not sure what that other one is.
Well, who put that on the door?
I know I put the one on the left on the door. I don't recall what the one in the middle is. I'm not sure what that one is in the middle.
Well, how many packets do you normally put on a door based on the violations that you observed on that day?
I normally just issue the imminent hazard of the notice violation.
I thought he made bail, this defendant, in which case he wouldn't be sitting in jail. But if he's not out on bail, he's in jail.
I show you D 500/5. And ask you if you recognize this document.
I see a
Yes,
comment.
it's
If the
the
defendant's
hazard.
acquitted, someone on the jury nullified. If the defendant's
And-
acquitted,
and
everybody on the
basically,
jury
what
would
is-
have to
what's
nullify.
the
It has to be unanimous,
purpose of
unanimous
this
verdict.
document?
If only
This
one person
document was
nullifies, it's
posted
just
to the
a
building, had
hung
imminent
jury, it's a
hazard, and
mistrial,
everybody that
and they
went to
prosecute
the
him again.
building or tried to get into the building knew that there was an imminent hazard and was able to read it.
And as you sit here today, I'm going to show you 872.
I understand how time zones work, folks.
Which is
What I mean
the
is
other
that
document
we're
on the
20
door.
minutes behind the
recognize
actual
that
court
document?
proceedings in this video. So court proceedings are 20, 25 minutes ahead of us, and we're 2 hours behind. So in terms of what's actually happening in
Yes,
court
that's
now,
the letter for
compared to,
temporary
relative
housing
to what
that
we're
the
watching on this
town
video,
had.
they're roughly 2.5
asked for.
hours ahead of us, clockwise.
Judge, I move 872, which is the.
I'm going to stop
letter
explaining
from
it
the
because
town
it's
posted on the
obviously too
door that's
confusing.
already
I'm doing
been
a poor job
introduced into
explaining it.
evidence, and the specific violation 500.
It's going to object to this report. The state will object. They'll have a sidebar.
81, which shows both documents.
I think if it's the two pictures and
Right.
the actual violation that was posted, I don't have an objection.
But not the
I just
report.
confirmed
Yeah, just show Mr. Shellhorn what it is you're moving in specifically.
I don't believe this defense lawyer is a public defender. First of all, he's too bad to be a public defender. I mean, most public defenders are quite good. They get a lot of trial time. And I just can't believe a public defender of any experience would be this terrible. I mean, even if they want it to be bad,
Any
it's hard to be
objection?
bad if
Sorry.
you have the trial
What are those
time of
numbers
a
again,
public
Mr.
defender.
Marcus?
800-81, 800-72, which is the letter, and the specific violation 500-5.
Fine. Those matters will be admitted into evidence. No objection from the state.
And I'd like to publish these to the jury.
Certainly.
I'm putting on the screen 800.
Yeah, so this is testimony today. These are trial proceedings from today. We're about 20 minutes behind what's actually happening in court, folks. Well, good point. The defense attorney was chosen by arguably a crazy person.
Okay, you got to turn the image, please.
Oh, the bailiff Jersey Mike is back. Oh, for people wondering about the laptop, you don't normally see a laptop in front of a witness stand. They're just doing that in place of or as an adjunct to a TV in the courtroom where electronic evidence can be displayed.
Judge, if I could just quickly show the jury very quickly.
Sure.
Yeah, I know this defense lawyer's LinkedIn page apparently says he's got 30 years criminal trial experience, which is hard to believe, but if true, just goes to show that doing something a lot doesn't necessarily mean you're doing it right. Right, ladies? Regarding the comment about Chad Reed and Kyle Carruth, our live show yesterday covered that
Imminent hazard. That was posted on the door.
in a modest way.
Thank you. Mr. Lopez. I'm not going to ask you the specifics, but did you have a conversation with Michael Barisone about where he and all the people who were residing in the stable area were going to sleep?
Yes.
I think this defendant had plenty of money.
And did you come back?
That's what I've heard.
At any point and see mattresses laid out outside on the front porch?
And plenty of money with which he could have hired competent legal
And
counsel.
when did you see those mattresses on the back porch?
At the time that the violation, the imminent hazard had stated.
I mean, he wasn't impoverished or he would have had a public defender.
Now, did Michael Barisone and all these staff members there comply with your order to vacate the premises?
They abated the violation by not sleeping there and removing the mattresses, so yes.
Now, did you have any discussions with Lauren Kanarek with regards to her staying in the farmhouse?
Evicting
She
someone's
emailed
not like
us
pressing a button
saying
and
that
they
she
were
had received
ejected from the building,
violation.
folks. Eviction takes a long time in New Jersey and many other places.
Confirmation she
And
was
he'd only
aware of it,
begun a
correct?
formal eviction
Correct.
process like a day or two before the shooting happened. Prior to that, he was asking her to leave and she was refusing, which is not
Did you come
legal
to an
process.
arrangement
And by the time he started the legal
with
process, he
Lauren
was only a day
Kanarek?
short of shooting her.
Whereupon she was allowed to stay in the farmhouse?
She and Robert Goodwin abated the imminent hazard, and therefore the imminent hazard was abated, and I could not, there's no reason for me to be able to keep them out.
You basically gave them permission based on what,
Under the fire code,
under the fire code, to go back into that residence, correct?
because the imminent hazard was abated.
And to your knowledge, did she or Robert Goodwin take down those violations that were posted with the
So
arrest?
this sounds
Yeah.
legal.
How would he know that? He'd only know it if he returned to the scene, and we haven't established that yet.
Did you return to the scene at any point to check to see whether those violations were abated?
No, it was late at the night, and they sent me emails with photos of everything in working order and video of the smoke alarms working.
So you did that based on what they told you, not what you saw or investigated, correct?
It was late at night, and I was not going to go out to the farm late at night. They sent us emails and videos of all the devices working properly.
Okay.
Well, that was very considerate of him. Didn't have to do that.
When Michael Barisone was violated for the stable area, did you advise him of the violations concerning the farmhouse, because he was the owner?
I did.
Now, after you allowed Kanarek and Goodwin to go back into the residence, did you at any time notify Michael Barisone, the owner, what you had done?
Not that night. I didn't. We were going to do it in the morning.
Did you do it in the morning?
I did not get to it in the morning. No, we did not. No.
So as far as Michael Barisone was concerned,
Objection.
Yes, Mr. Belinkus, not
Spec-
proper, sustained.
Speculation. You have to have him testify about what he knew.
so before the shooting, did you notify Michael Barisone that Kanarek and Goodwin were allowed to remain in the residence?
I did not have contact information for Michael, so no.
Did you or anyone on your behalf go out and remove those violation notices?
Nobody from my office removed the violation notices.
And those are the violation notices that I showed you in that picture, correct?
The ones that were on the door of the house, yes.
I can have a moment, Judge, I take them back.
Sure.
Did you have anything to do with the stop construction orders?
No, that's UCC construction.
I have nothing further, Judge.
So
Cross-examination.
Thank you, Your Honor. So, Mr. Lopez,
this is another weird thing to me in this courtroom. This prosecutor is now going to conduct cross, which is fine. He's going to conduct cross from his seat. That's not the norm. I mean, a court, certainly a judge can allow whatever he wants in his courtroom. But unless this prosecutor is paralyzed, I would expect him to stand up to engage in direct questioning or cross-examination of witnesses, or to speak to the judge in any manner.
you were there on August 6th and issued a number of fire violations at the house,
Correct,
and you also issued a number of fire violations at the barn.
correct.
And I think just to clear up what you were just asked about, you got an email from Ms. Kanarek.
We do get better
on
audio when they
the
stay
night
in
of
their
August
seats.
6th,
That's true.
2019,
Correct.
and she actually sent you videos and pictures that showed that there were fire detector, smoke detectors and things of that nature.
Yes,
And from your perspective, that abated the hazard that you had observed, the imminent hazard, at least for purposes of that night.
correct.
When you were at the property at some point on August 6th, Mr. Belinkus asked you about seeing mattresses outside the barn.
Correct.
And during the course of dealing with Michael Barisone, did he tell you that he was going to be getting a hotel?
Correct.
And you found that to be satisfactory because
The barn is not a dwelling unit, so nobody should be staying there.
whose responsibility is it to fix or remedy or abate an imminent hazard?
The owner, operator, tenant, occupant.
And in this case, you actually had Ms. Kanarek and Mr. Goodwin abated what was going on at the barn, but nothing was abated at the, at the house, but nothing was abated at the barn.
No, the barn was abated. The mattresses were removed, so there was no dwelling units inside the barn anymore.
I understand. Nothing further, Your Honor. Thank you.
Any redirect?
No, sir.
All right, you may step down, Mr. Lopez. Thank you.
All right, that's it for Lopez, the least looking Lopez I've ever seen.
Might call your next witness.
Oh, at some point, I'm going to have to get something to eat. Maybe some Jersey Mike's.
Dan Vitale.
Lopez is a race.
The 10th call is Mr. Dan Vitale.
Dan Vitale.
Dan Metallic. This is like a junior high school novel version of a trial with these name selections.
Hi, Mr. Vitale. How are you? Good. The left hand on the Bible, please. Raise your right hand. Please listen to my court clerk as she administers the oath.
Do you swear in the presence of Almighty God that the testimony you give to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name and spell your last name for the record.
Daniel Vitale,
Looks like he just finished washing the judge's
All right,
car.
you may be seated, sir. Please keep
Does
your
valet
voice up nice
parking
and
out
loud.
in
That
front of the
microphone
courthouse.
Only records if it does not project your voice in the courtroom.
Okay.
All right, so they have to hear your voice. If you don't understand a question, please indicate that. I'll have counsel rephrase.
Okay.
All right, go ahead, Mr. Malinkas.
Mr. Vitale, where do you currently live?
I currently live in Morris County.
And what do you do for a living?
Currently, I'm a firefighter paramedic.
Directing your attention back to August 7th, 2019, where were you working?
St. Clair's Hospital EMS.
And
I'll be back in just a second, folks.
Do you have become EMS?
I went through EMT school, and then I went through paramedic school to become a paramedic where I was working at the time.
And how long were you working there prior to August 7th, 2019?
I would say it was a few years prior, maybe 3 or 4 years prior to that date.
So again, your title is or was exactly what back then?
Mobile intensive care paramedic.
Okay. On August 7th, did you have an occasion to come into contact with my client, Michael Barisone?
Yes.
And how did that come about?
We were called to an address, and we were dispatched there through our dispatch center and responded to that address where he was located.
All right. Do you recall what the address is as you sit here today?
I don't recall. It's on my patient care report.
Okay. I'm going to show you D605. And ask you to take a look at that and see if that refreshes your recollection as to where you went and saw my client, Michael Barisone.
411 West Mill Road in Long Valley.
Right. And you're referring to what? An official document that was made?
Yeah, this is our patient care report.
And what's included in this type of report?
Obviously, all the dispatch information, times, and our exam findings.
Were you there with someone else from St. Clair's EMS services?
Yes, we ride 2 paramedics in New Jersey, so my partner, Kimberly Held, was with me.
All right. And at some point in time, did you come into contact with Michael Barisone?
Yes.
And did you assess and treat him?
Yes.
In assessing him, did you attempt to determine what happened?
We did attempt that, yeah.
And what was he able to tell you about the incident?
Judge, can we be heard at sidebar?
Yes. Let me see that sidebar, please.
What happened? We jumped right into sidebar. See the defense lose this one too. Let's see. Is it worth jumping ahead? Looks like they're going to start up in just a minute. Meanwhile, I saw someone mention ramen. I got a little version of that myself. Intermittent fasting, folks, so I don't eat anything till 1. I miss Blinkus's power pose. He likes that power pose.
Mr. Shellhorn, let me see you again, please.
Oh, Shellhorn is the prosecutor. Is that a Corvette jacket? This witness came to court to testify wearing a Corvette jacket? Good Lord. Yeah, so they objected on hearsay, I presume. Although it could be an exception, but it would be exception against interest.
Did you ask him what happened?
We did.
And what was his response?
His response was that someone was there to take his kids, and he couldn't remember really much of anything.
Did he give you any information as to the actual event?
No.
Yeah, it could be admissible as an excited utterance or some other exception to hearsay.
Now, did you make note of his present mental status?
We did.
And what was your observations of Barisone while you were treating him?
Confused.
Did you receive information from anyone else?
I mean, I don't know. I was never an
Scene
EMT, but I drove an ambulance and
that you
they gave me a
used
uniform
as far
as a mere driver.
Treatment that you did?
I don't really understand the question, though.
Okay, I'll try to rephrase it. I'm not sure I do either. Did you see any injuries on Michael Barisone?
We did, yes.
Did you get information from anyone other than Michael Barisone as to what may have caused those injuries?
We did, yes.
And what was that?
The police
I'm
department.
going to object to the form of the question as hearsay, or it calls for a hearsay response.
But these are statements from others, not from,
Is there statements with regards to specific injuries, Judge, that he used to determine what medical attention was necessary?
is that why, did you ask others the question about what happened? Or did they volunteer the information to you?
They volunteered as we arrived on scene.
And who specifically did you speak to? Do you recall?
A patrolman. I don't remember his name. It is reflected in my patient care report. He was the one that transported with us.
And he gave you information, and what was the reason? Did you need that information?
It's pretty typical when the paramedics arrive on scene that the agency that's currently there gives us an update as to what's going on, so we kind of know what to do and who to approach, who might need our services, who does not.
All right. So at that point in time, when you heard the statement, you didn't know who might need your services?
Oh, no, because we were just arriving on scene.
All right. So let me see that sidebar, please.
Good Lord.
Did you observe various injuries to Michael Barisone's body?
Yes.
So again, the state
You
won. He's back to his
exact
personal observations,
photographs.
not what other people told him.
852 to 871. And could you just take a quick look at all of those?
While the witness is looking at those, perhaps we can come to sidebar.
Another sidebar.
You know what, why don't we do this? It's 10 after 3. We'll take our afternoon recess. We can talk about this outside the jury's presence, and then we'll proceed. All right. All right, we'll take 10 minutes, ladies and gentlemen.
All right. Well, that'll pretty much catch us up. I think. Yeah, I know. I've heard that over at Law and Crime that the chat before the judge shut it down was extremely critical of this judge. I think this judge is really quite reasonable, given the performance this defense counsel is putting in. Where's Borkowski when we need him? By the way, speaking of Borkowski, the sentencing for Theodore Edgecombe is this Friday by Judge Borkowski. That's the case in which the bicycle rider shot the immigration lawyer dead. Edgecombe was found guilty and now is being sentenced on Friday. I'll be joining Nick Rekieta on his channel for that sentencing, so that should be great fun. I may even be tieless. We'll have to see. Well, that's it. I'm completely caught up. So, yeah, the Edgecombe sentencing should be great fun. Judge Borkowski is. I don't expect him to go easy on Theodore Edgecombe by any means. And I can only imagine Borkowski should be just a joy on that sentencing. No holds barred, Borkowski. The sentencing is Friday. I don't have a specific time. I don't remember if they announced a time. I was going to check closer when I got the date. Yeah, Edgecombe from Barangi in the comments. Edgecombe to the judge after sentencing. Can you repeat that sentence? Borkowski may just give it to him again. Correct. Having a little ramen-esque quick meal, folks. So for those who don't know, I'm intermittent fasting, which means I don't eat anything till 1 o'clock. It's 1:30 my time, so I'm already a bit behind the curve. But that last hour, I start getting pretty hungry. So that's the explanation. And for those who follow me on Instagram, I've been doing a public gramming on my current fitness regimen to lose weight. Tomorrow is my third week in my open public official weigh-in tomorrow. So we'll see what's happened in the last 3 weeks. I started 3 weeks ago at 222 massive pounds. We'll see where I am tomorrow morning. Hopefully things have improved. Although of those 3 weeks, a week of them I spent at the Tactical Conference 2020 in Dallas, where I was eating steaks and food truck meals and not exercising at all. So a week of the 3 was pretty much a throwaway, if not a step back. But nevertheless, I hope the other 2 weeks in which I've been reasonably disciplined on the diet is had some positive results. Yeah, I'm 6'1" and change, so 222 is way over. Yeah, for sure. I should be more like maybe 190. So that's the goal, the near-term goal, somewhere between 190 and 200. Well, hopefully I'm not 222 at the moment. I mean, I've been fasting myself for and running. So in addition to the intermittent fasting, I also do caloric restriction. I'm only eating around 1,200 calories of food a day, and I'm running about 1,000 calories a day. So the net caloric intake's pretty darn low. So hopefully I'm well below, somewhere below 222 come tomorrow morning. We'll see. I'll be go to my Instagram. You can find me at lawofselfdefense.com/Instagram. We'll bring you to my page, and somewhere in there you ought to be able to see my little less than 1 minute Instagram videos where I do pretty much every day tracking my progress. Running 1,000 calories a day. So usually, I mean, these are little pathetic runs. Don't get me wrong. Run in the morning, run midday, run in the evening before I go to bed. Each is about 300 calories. So that's like 30 minutes of, old man jogging. "30 minutes old man jogging 3 times a day," to be clear. Yeah, I'm not a nutritionist, folks. All I can tell you is when I intermittent fast, restrict calories to around 1,200 a day, and run about 1,000 calories a day, I lose roughly 3/4 of a pound a day consistently over a period of weeks. So, yeah, the knees are touchy. I actually, I have friends tell me, "Oh, you're lucky you can still run." I mean, my knees are sketchy. I have to wrap them up to be able to run. If I tried to run without the straps on my knees, I wouldn't get very far. Yeah, don't take advice from me on nutrition or diet or fitness. I don't claim any expertise in any of those. And just because it works for me, and it demonstrably doesn't mean it would work for you. So don't go jacking yourself up on the Andrew Branca fitness regimen and then complaining to me about it. Yeah, and I hate running. I mean, I hate it. That damn treadmill is a torture device as far as I'm concerned. But if I hate anything more than running, it's riding a bicycle. I loathe riding a bicycle. So unless my knees completely collapse and make it literally impossible for me to run, I'll be on the treadmill before I'm ever on a bike. Let's see. Man, they're still going, huh? I would fast forward, folks, but I'm all caught up. So I've got to wait for this circus to get its feet back under it. I do run outside. I'll start running outside again now. The weather's only just recently gotten good enough for that. And we do have a lot of hiking trails out behind my house. I live in Colorado, so I've been doing that as well. And they're great. Lots of elevation change. Not quite as efficient in terms of burning calories over unit time as a treadmill, but certainly a good variety out in real world, smelling the flowers and all that. Yeah, so you're right. Somebody is chastising me for not grifting the whole time. I'm not selling any diet plans, folks, but I do have Law of Self-Defense hard to convict webinars coming up this month. We got 5 of them scheduled. The first one is 2 days from now, Wednesday, April 6th, where we'll engage in an hour or two of busting very common self-defense law myths, the kind of myths that, if believed, could send you straight to prison for much of the rest of your life. And we'll also be doing extensive Q&A with the audience. These what? Good heavens. Sorry about that. These webinars, these hard to convict webinars are 100% free, but they're filling up fast. They're about 70% full right now. And I only started talking about them a couple days ago. So if you're interested in attending one of our 100% free hard to convict webinars, point your browser to lawofselfdefense.com/hard to convict and grab your seat before they're all gone. I'm not sure what trials are next, folks. I don't usually have to bother looking too far ahead. They're constantly popping up on my radar screen. I hadn't really planned to cover this one, but it just popped up. So no big high-profile cases on use of force law that I'm aware of at the moment, and I can only cover one at a time. So as soon as this one is wrapped up, I'll be moving on. Yeah, so I know Nick and some of the other law tubers are covering the Johnny Depp trial. Amber Heard, is that the woman's name? Amber Heard and Johnny Depp. But it's not a use of force case, so I won't be covering that. Yeah, I mean, this trial's proven pretty boring, but it looked like a kind of a sketchy self-defense claim, and I thought it worth seeing what the defense could make out of it. I mean, you don't really know what the merits are until you hear it argued out in the adversarial forum of the trial. And it's possible that there's more to a case than you might think from the media. Certainly that was true in Rittenhouse and Zimmerman and many other cases.
Ms. Radler, are there any other people, observers outside that want to come in? All right. If you're here, I'm going to ask everyone to remain throughout the testimony. If we get a break in the witness, you can get up and leave. But I have heard some complaints made by the jurors that they're distracted at points because of people walking in and out of the courtroom. So if you're here, just remain here. We don't have too much longer today. Just remain here. If you have to go somewhere at 4 o'clock or something, then I'm going to ask you either to stay or leave now. I don't want the jurors being disturbed by people walking in and out all the time. Thank you. And Ms. Radley, can you just check outside if there are anyone else that wants to come in? They need to come in now. Otherwise, they're not coming in.
Chatter, chatter, chatter. Come on, folks. I wanted to jump ahead, but I can't. So for the super chat, just came in from Accuracy Firearm Training. Can the defendant fire his defense attorney at this moment for any reason? Ask for a public defendant. Those are two different questions. So can he fire his lawyer? Sure. The judge might give him a hard time doing it, but ultimately it's at the discretion of the defendant. If he's mentally competent to stand trial, presumably he'd be competent to act pro se and defend himself in court. I mean, it's not a smart move. Or he could retain a different attorney if he could find an attorney to step into this train wreck in the middle of a trial, which seems unlikely. That's one question. Can he fire his attorney? Sure. Can he ask for a public defender? Well, you can always ask. But you don't have a right to a public defender. You have a right to a public defender if you cannot afford to pay your own attorney, which most often means you're destitute. You have nothing. I don't think this guy has nothing.
So
I don't think he'd qualify for a public defender.
Me at the break that there were a couple complaints about people walking in and out of the courtroom during testimony and the doors slamming. I've spoken to the people in the courtroom now and told them they have to wait until a break in the witness testimony. And my staff has also checked out in the hallway to make sure that people who wanted to come in and see the testimony are already in here. And hopefully we'll keep that at a minimum. If it happens again, I'll see it. I'm sorry I missed it before, but
did the jury complain because they were unable to pay attention, or did they complain because the door slamming was waking them up?
Sorry for the disturbance. But Mr. Vitale's on the stand. We'll continue with examination. Go ahead, Mr. Belinkas.
Thank you, Judge. Mr. Vitale, I'm going to show you these photographs. First, 852. Does that photograph accurately depict the injuries to Michael Barisone's face area?
Yes.
$855. Does that photograph accurately depict the injuries to the left side of Michael Barisone's face?
Yes.
So for those coming in late, so Michael Barisone was physically beaten by Lauren Kanarek and her boyfriend, Robert Goodwin. They've testified that they beat him after he shot them. So in essence, they were beating him to prevent being shot again. They were beating him in self-defense. The defense, I'm sure, would like us to believe that he was beaten first and then shot them in defense against the beating. The trouble is there's no actual evidence of that sequence of events. I mean, where would that evidence come from? There's 3 witnesses present, and there's the Kanarek's lawyer on the phone. But the 3 witnesses present are the victims here, Lauren Kanarek and Robert Goodwin, and then the defendant, Michael Barisone. If he's not going to take the witness stand to tell his side of the story, where would the evidence of the sequence of events come in that would be contrary to what Lauren Kanarek and Robert Goodwin have told the jury, that they dealt out the beatdown after they were shot?
$864. Does this accurately depict the injuries to the right side of his face?
Yes.
$866. Does that accurately reflect the injuries to his left side?
Yes, it does.
And when you were examining him, he didn't have a shirt on, correct?
Lauren Kanarek simply struck Michael Barisone with her phone.
I don't
The
believe he had a
beating that
shirt on.
resulted in injuries was inflicted by Robert Goodwin, who was not shot. He was shot at.
56. Does that accurately depict his left arm and the injury that he suffered?
You can't really see much there.
Should I
since
send
it's
this
bandaged up, but,
witness
he did
my
have
fitness
injuries to his
regimen,
left
you
arm,
think?
So I would assume that's probably.
Okay. Now, with regards to his injuries, did you document your initial physical findings?
Yes, on the patient care report.
And with regards to the head area, what was your findings?
Can I refer back to the
If you
report?
needed to refresh your recollection.
Has that document been marked, Mr. Belinkus?
Yes, Judge.
Can you just, for the record in my notes?
600-5.
Thank you. 600-5 is what the witness is referring to.
Judge, I don't have an objection to the witness referring to that as long as the record's clear about whether he's testifying from his memory or from what was documented in the report.
Understood.
I think he's refreshing his recollection now.
Yeah, that's fine.
Yes, okay.
So what were your observations and your physical findings regarding the head area?
Abrasions, hematomas.
What's a hematoma?
It's a bruising to the face. in there. It's a bruise.
And a laceration?
The
Yeah, he
opposite
had
of a
lacerations,
shiatoma.
And that were also on his face on all sides too.
How about the face? What did you observe on his face?
Those injuries that I just mentioned were on all sides of his face. His face and the left side of his head, as far and the right side of his head as well.
Did you notice any injuries to both of his ears?
Not specifically.
Do those photographs that you've reviewed refresh your recollection with regards to injuries of the ears?
Yes, it looks consistent. Yeah.
How about his the general back area? What did you observe there?
The back area.
can
You mean his
refresh your
buttocks?
report If you need to.
Yeah, I'll have to just look again because
Go ahead. Again, for the record, he's referring to his official report. With regards to his back area, what did you note?
1 second.
So-
on here, I have it noted that his back examination appeared to be normal. There were some abrasions, otherwise normal.
How about the left arm, upper arm?
The left upper arm, if I could just refresh my memory here, looks like his left upper arm did have abrasions still, punctures.
And was,
Folks, reasonable
Avoided
doubt is
blood
not
that
the
you
same as speculation. Speculation,
It's not on here,
imagination
but I remember that
is
there
not
was
reasonable
dry blood
doubt.
in there from
It could have gone this
abrasions
way
and
is not a
puncture
reasonable
wounds.
doubt.
right, how about the right upper arm?
A reasonable doubt has to be based on the application of the powers of reason to evidence. It's not just imagining some
It's
alternative
still,
hypothesis.
Abrasions on here. Right upper abrasions, yeah, abrasions, some controlled bleeding.
Okay, what did you notice about his left forearm?
His left forearm, I do remember it was kind of weak. He was in handcuffs, but it seemed like that arm was like weak.
Objection
difficult for him
by the
to move
defense.
compared to the other upper extremity.
And did you notice any deformities in that arm?
I don't specifically remember a deformity to it, but he was also in handcuffs, so his arm was already a little in an awkward position.
Did you make any reference in your report with regards to the left forearm findings?
Yeah, with the motor function being abnormal / weakness. To me, that was him moving that left arm seemed decreased.
Did you notice any puncture wounds on the left arm?
Yes, we did have that side of his body had puncture wounds, yep.
How about his left upper leg area?
His left upper leg area was bandaged prior to my arrival, so I couldn't do much of an exam on it.
And did you receive information with regards to who bandaged it and for what?
No object to for what, Judge? For the reasons stated.
Overruled. I'll allow it.
Wow, defense wins one.
As far as who bandaged it, I don't remember.
I wonder if that's
who
the first
bandaged
objection
the
they won all
injury.
trial.
And what was it bandaged for?
On this, yeah, for the dog bite.
Did you find any other puncture wounds on his body?
Left upper extremity. Left shoulder, I believe.
How about his right eye?
Yeah, so the witnesses were the defendant, Michael Barisone, the victims, Lauren
The radar
Kanarek, and
findings,
her boyfriend,
saying
Robert
that
Goodwin,
there was
and
laceration
the
there,
dog
which
of
is
Lauren
consistent with
Kanarek,
the rest
who
of the
also
head
attacked
assessment
Michael
that we did
Barisone with his
And
teeth,
what did
with
you
jaws,
notice based on your
let loose the
observation
dogs
was his,
of Lauren Kanarek.
mental status?
But again, of course, the state's arguing all
Confused,
that happened
altered
after
mental
the
status.
shooting, which would be consistent with the victim's testimony. The
Did you
dog,
put that in your
as much as
official report?
we might hate this fact, the dog was not called to testify.
Judge, at this time, I would move into evidence 852, 55, 64, 66, and 56.
All right, 52, 55, 56, 64, and 66 will be moved into evidence. The court and counsel previously addressed any objections to those photographs. Those were allowed in by the court.
Okay, Judge, my Elmo doesn't seem to be working. I'd like to just publish some.
Sure. Go ahead.
Judge, while Mr. Belinkus is doing that, I'll just put on the record, he's gonna determine the day when photo 66 was taken. It was not taken on the day of the incident. He doesn't have that right now, but he is gonna get it for the record.
All right, thank you.
Now I'll display 55. Your way back.
Mr. Belinka, so you're gonna walk back and forth 5 separate times?
I don't know any other way to do it. Judge.
Just hand juror number 1 the stack of photographs. They can pass it down. And then when juror number 7 is done, you can take it and pass it to the jurors. Just have them pass it
Save
along.
me some miles, Judge. Thank you.
Just give him the whole stack, let him review it, and then he can pass it on.
Thank you.
Yeah.
Thank you, folks. I was just saying, we might wish we lived in a world where people who are as monstrous and torturous as these victims, Lauren Kanarek and Robert Goodwin, were to this defendant, Michael Barisone. Apparently, they sought out to destroy him and appear to have succeeded with malice and intent. But being super mean to someone is not justification for them shooting you. Yeah, Law and Crime had announced on their live streaming of this that the court has ordered them to shut their chat off if they wish to continue streaming. So I don't know why. One can only speculate. We are caught up to the
Mr.
live
Belinka, you want to
stream.
hand those to juror number 8?
That's why
please?
I'm not skipping past this. Sorry, folks. And I just got confirmation that my new holster is on its way. That's always good news. Yeah, so the fact that only the victims and the defendant were personal witnesses to this event doesn't mean that there's no other way. There's no way for a viable theory of self-defense to have arisen. There is other evidence. There's forensics evidence. There's circumstantial evidence. The trouble is that none of it, absent the defendant's testimony on the facts of this particular case is consistent with self-defense. Well, am I armed on the treadmill? Well, my treadmill is here at home, so it's I'm never far from a means of self-defense at home. Got into self-defense law because I was a very active competitive shooter and member of the gun community and self-defense community, NRA instructor in pistol, rifle, personal protection. Relatively fresh out of law school. Everybody in my tribe was asking me questions about what was lawful or not lawful in use of force law, and I didn't know the answers. We were not taught this in law school. So I started educating myself on self-defense law in Massachusetts. And then because New England states tend to be small, in all the adjacent states, Vermont, New Hampshire, Connecticut, Rhode Island, realized there was a common pattern there, the pattern that would turn out to be the 5 elements of self-defense that I found in all 50 states. That's what led me down this path, realizing I could perhaps contribute something back to
Might the
that
jurors have viewed all the
community
photographs?
through that
Please,
observation.
Proceed, Mr. Blinkus.
No further questions.
Mr. Shellhorn, cross-examination.
Thank you, Your Honor. Mr. Vitale, you traveled in the ambulance with the defendant and another partner?
Yes,
What was her name?
Kimberly Held.
It is a
And
Corvette
did
jacket. Oh my
Patrol
God.
Officer Hensley ride in the ambulance with you?
Yes,
And why would you button
Now,
up
you
your shirt to
indicated
the top
that
button
Mr.
and not wear a
Barisone
tie?
Was alert and conscious during the transport?
yes.
He was alert to person
Person and place.
and place.
Yes,
And you
I
didn't
have
note
taught
any
at the FBI
neurological
National
deficits?
Academy
No,
several
other than
times.
his confusion.
His speech was normal?
Yes,
And you indicated that he made some statements during the course of the transport?
yes,
He indicated someone drove down my driveway and said she was going to take my kids.
yes.
Did he also
Judge,
state,
can he read the entire passage? Left some out.
Was there something left out, Mr. Shellhorn?
there are other comments in there, Judge, I just want to focus on that part of it.
He left out.
Hold on. Don't say, well, let me see that sidebar.
Another sidebar. Good Lord. I'm not sure teaching at the FBI Academy makes me a glowy. I'll tell you one thing, it's fun to shoot at the FBI range. They have guns in the armory that are just a joy to shoot, and they provide the ammo. So I'll go anytime I'm invited.
Can I see the one you marked? And that's 605 for the record, Your Honor. Does that indicate, in quotation marks, someone drove down my driveway and said she was going to take my kids? That's all I remember.
Yes,
And was that put in quotation marks because it was a direct quote?
it was.
So for some context here, so immediately prior to the shooting, now they Lauren Kanarek and Robert Goodwin had been saying all kinds of horrible things to and about the defendant, Michael Barisone. They'd accused him of all kinds of misconduct, and including they had accused him publicly of having molested the child of his girlfriend, Michael Barisone. But then just before the shooting, in that final meeting, confrontation between them, apparently Lauren Kanarek had threatened to call whatever the New Jersey equivalent of Child Protective Services is and have the child of Michael Barisone's girlfriend taken away into, what Child Protective Services does. And it was at that point, Michael Barisone said, that his memory of the event ceases. So this is before shots are fired. It's before he's physically attacked. They make that threat. Lauren Kanarek makes that threat to have his girlfriend's child seized by the state. And he loses all memory from that point on until he wakes up later in the ambulance or in the hospital. I forget which. So Michael Barisone himself claims he has no first-person recollection of the actual fight, which might make it difficult for him to take the witness stand and testify about the actual fight.
Did the defendant also report that his heart was hurting, but not physically?
That was also quoted, yes.
Meaning that it was putting quotes into the report because that was the exact words that he used?
Correct.
Thank you, Mr. Vitale. No further questions, Judge.
Right. You may step down, sir. Thank you. You have another witness, Mr. Blinkus?
Yes, Judge. Kimberly Held,
All right. Kimberly Held?
H-E-L-D.
Held. Okay. Kimberly Held.
As far as cool guns I fired, folks, I fired a lot of cool guns. I just get invited places where I have that opportunity. FBI Academy and elsewhere. I mean, I fired M1919 machine guns, belt-fed machine guns, M249s, grenade launchers, Thompson
Ms. Held,
submachine
how are
guns
you
from the
conducting
Prohibition era,
Please remain standing. For a
integrally
moment.
suppressed
Place your left hand on
MP5s,
the
all
Bible on the
kinds of
witness
stuff.
stand. Please raise your right hand. My court clerk will administer an oath.
Do you swear in the presence of Almighty God that the testimony given to this court regarding this
Barretts,
matter shall be
lots
the
of
truth, the whole
Barretts.
truth, and nothing but the truth?
I do.
Please state your name as well, your last name for the record.
Kimberly Held, H-E-L-D.
All right, you may have a seat, ma'am. Please keep your voice up nice and loud. That microphone only records. It does not project your voice in the courtroom. All right? Very good. If you don't understand a question, please indicate that to me and I'll.
What kind of a
have counsel
system is
rephrase
that?
the question.
Jeepers.
Very good. Mr. Blinkus, direct examination.
Ms. Held, directing your attention to August 7th, 2019, where were you employed?
St. Clair's Health,
In what capacity?
a paramedic.
And have you ever heard of intermittent
What
fasting?
training, if any, did you have as a paramedic to obtain that position?
I received an associate's degree in paramedicine science at Bergen Community College.
Does she have food in her mouth right now?
And how long had you been working for St. Clair's up to that point?
A little short of 2 years.
I'm going to direct your attention to August 7th, 2019. Did you have an occasion to respond to?
Yeah, we're caught up, so this is live stream now.
Yes.
And was that Michael Barisone's farm, do you know? And why did you respond there?
We were dispatched by our communications.
And upon arrival, at any point in time, did you have an opportunity to see my client, Michael Barisone?
Yes.
And did you treat him?
My partner treated him.
And were you there observing?
Correct.
And can you tell me what his mental status was when you were treating him?
Upon our assessment, he was altered and confused.
In doing your assessment, did you ask him specific questions as to what had happened on that day?
Yes.
And what did he indicate to you in response to those questions?
May I refer to my
Please.
report?
All right, let's have that marked, please. That's your own copy, ma'am?
Yes,
All right,
yes, sir.
just for the record, we need to mark a copy.
My apologies.
No apology
I'm
necessary.
going to show you a copy of your report.
Just make sure that's the same document that you have.
D600-5.
Okay.
Michael Barisone owned a horse ranch. He invited this woman, Lauren Kanarek, and her boyfriend to live there to be trained in dressage. Relationship went hostile to the point where Michael Barisone shot Lauren Kanarek, and her boyfriend, Robert Goodwin. Shot her twice in the chest, shot at the boyfriend, missed him, 2 counts
So
of
for
attempted
the
murder.
report, it states someone drove down my driveway and said, she was going to take my kids. That's all I remember, end quote.
Was he able to describe or tell you any events that occurred on that day when asked?
Nothing else.
Did he say anything about his heart?
Yes, there's a quote stating, "My heart hurts, but not physically," end quote.
Did you have an opportunity to observe the injuries on Michael Barisone?
Correct. There's in detailed reportings of his injuries on the report.
And I show you D856. Did he have an injury of his left arm that you observed?
It was reported here that
Well, she
his
should not
left
be
upper
reading
arm findings,
reading
PD
reports,
reported dog bite upon left upper.
and we already had
Left
testimony
upper.
on this.
Peter reported left forearm has deformity, ice pack and splint was applied prior to ALS arrival, multiple abrasions and puncture wounds to the left arm.
How about his left side, his torso area?
I wonder if bailiff Jersey Mike is giving her the "call me maybe" sign from across the courtroom.
Irrespective of what's in your report, did you observe these injuries to his left side at any point in time while you were treating him?
Not to my recollection.
Okay.
I'm sorry, I didn't catch that
I
answer.
said not to my recollection.
Speak
Just
up.
make sure you keep your voice up, man, because our jurors in
My
the gallery
apologies.
have to hear.
Use those lungs.
D864. Did you observe injuries,
Head findings were multiple hematomas on both sides of his head.
and does that photograph accurately depict those injuries?
So when the boyfriend Robert Goodwin testified, he testified he was putting a beat down on Michael Barisone. No question about it.
Bruising
Punched him
noted on
repeatedly in the
side
face
of
and
the
head,
face
put a
and left
chokehold
ear
on him.
blood.
But he says all that was after his girlfriend, Lauren Kanarek, was shot by this guy, and he himself was shot
Correct,
at.
bruising noted.
Now, at some point in time, did you have a impression / diagnosis based on your treatment?
As paramedics, we do not diagnose, we treat what we see, and
Okay.
we were assessing for the altered mental status.
Okay, and what was your impression?
He remained altered, although we ruled out his hypoglycemia via glucometer.
I have nothing further.
Cross-examination.
You need this report here, counsel?
No,
Ms. Hill,
I don't need that
you
shitty
don't
report.
know specifically when the defendant said someone drove down my driveway and said she was going to take my kids. That's all I remember. You don't know if that's true?
No.
You don't know if he did remember or didn't remember?
That's what we were told.
No further questions, Judge. Thank you.
All right, you may step down, Ms. Helm. Thank you. You have another witness this afternoon, Mr. Blinkus?
Oh.
Can I have one moment, Judge?
Sure.
Please say no. Or at least put your client on the stand. I would stay for that. No, it's 4:14. They got to be wrapping up.
Defense calls Dr. Joseph A. Haney.
Oh, it's going to be the same line of questioning, essentially.
All right, Dr. Joseph Haney, please.
So, Super Chat, we are everywhere. Thank you for your contribution. Has a theory why long crime is banned.
Hi, Doctor.
Their chat.
Good afternoon. Please remain standing for a minute. You need to be sworn. So left hand on the Bible, raise your right hand. My court clerk will
Says the
administer an oath.
chat published Hustle Judge's
These
number
are
and
presence of
encouraged people to
Almighty
call
God,
and
that
harass the
testimony to this
secretary
court
because he was
regarding this
unfair
matter
to
shall
the
be truth,
defense.
the whole truth, and nothing but the
Maybe, I
truth.
don't know anything about that.
Yes.
I didn't watch
Please
the
state your
Hustle
name and spell
trial.
your last name for the record.
Joseph Haney, Heiney.
Thank you.
All right, doctor, you may have a seat. Please keep your voice up. Microphone does not project it
Is
over
that
the
his-
court, so
Okay.
we have to hear your natural voice in the court.
Is that his Porsche jacket?
If you don't understand a question, please don't answer it. Just indicate to the court you're not sure or you don't understand, and I'll have the counsel rephrase. All right, go ahead, Mr. Belinkus.
Doctor, where are you employed?
Currently, I'm employed at New York Presbyterian Brooklyn Methodist Hospital.
Directing your attention back to August of 2019, where were you employed?
At Morristown Medical Center.
In what capacity?
I was an emergency physician in training, resident physician on the trauma service that day.
Okay, and can you give the jury a little bit of your background with regards to your training?
I actually just completed training within the last year, 3-year residency in emergency medicine. Before that was in medical school, graduated school in 2018, graduated residency in 2021.
Really hoping to finish these residencies so I can get a girlfriend.
New York Medical College in Valhalla, New York.
All right, directing your attention to August 7th, 2019, did you have an opportunity to treat Michael Barisone?
I did.
Did he have contusions and hematomas?
Medical Center?
Correct.
Yes.
And did you
Had he
do
taken
an
a beating?
assessment,
Yes.
For your evaluation?
Yes.
What physical observations did you make?
Oh.
Any injuries to Michael Barisone?
So right off the bat, we noted that I believe his left elbow was deformed. We could see that pretty clearly as he came in. As we did sort of our head-to-toe assessment and speaking to him, I noticed there was the possibility of blood behind his left eardrum. It was unclear. It had that appearance, which worried us for a potential head injury. And otherwise, as noted in the chart, in terms of physical injuries, I don't recall much else.
Okay. I assume
The doctor's wearing a polo shirt to testify in court. I just can't.
It's been marked into evidence. 852. Does that accurately depict the injuries that you saw on Michael Barisone's face?
Yes, that seems correct.
How about
in my memory?
855?
I mean, at this point, I wouldn't even be confident this defendant gets a self-defense jury instruction. I mean, based on what?
And is that left ear the one you're referring to?
Yes.
864.
Seems correct.
These are injuries to his left side. Did you notice any injuries to the left side of his body?
If otherwise, as I stated, as noted in the chart, I don't recall off the top of my head. But
Okay. How about 856? Is that the left arm that you referred to as being deformed when you first observed him?
yes,
And what was done to that left arm?
so initially, we established that he had good blood flow past the injury of the elbow, a good pulse. We were still concerned for significant injury, possibly to other structures like nerves. We attempted to, we obtained an x-ray and determined it was dislocated. After which we attempted to reduce the dislocation. We did administer a sedative medication to do that. We're initially not successful, and out of concern for the potential head injury and other injuries, and the fact that the arm still had circulation, we elected to bring him to CT scan to further assess for other injuries. And eventually, once we were able to establish everything with the CT scan, we're able to relocate the arm with help of our orthopedic colleagues.
Right. Now, did you make note of his mental status?
Yes.
And what was that?
Well, when he came in, he was responsive. He was answering my questions to a degree and obeying simple commands. One of the important things we assess for things. incidental finding is such as a tumor, which would cause a mass effect.
That was
So,
long crime,
something,
folks, not me.
Grossly abnormal about within the skull.
Thank you very much, doctor. No further questions.
Oh, they jumped way ahead.
Any follow-up?
No.
All right, you may step down, doctor.
They jumped
Thank you
from the
very
middle
much
of
for coming to
direct
court.
all the way to the end of cross by the state. Good job, long crime.
All right, we'll break. It's 4:20 or so. So members of the jury, we're going to break, recess for the evening. Please don't discuss the case with anyone. We'll see you tomorrow morning, same time. We'll get going as close to 9 o'clock as we can. So please get here around 8:30. Thank you.
All right, folks. So I guess that's it for the day on this. The only thing that would be interesting to me in this trial moving forward would be if the defendant took the witness stand. So I'll keep my eyes open for that. I'm not going to schedule anything formal ahead of time, but if I get word or notice that the defendant's going to testify, I'll pop up a live show real quick. Before I close up, I do want to remind everybody, because time is now getting short, that we have our Law of Self-Defense Hard to Convict webinars coming up. These are 100% free webinars where we'll bust the most common use of force law myths, the kind of myths that are, if believed, would send you directly to prison. Do not stop. Do not pass go. Do not collect $200. No reason to believe these things, but they seem everywhere because they're on the internet and gun magazines, and people, self-defense instructors, concealed carry instructors, people repeat these things ad nauseum. We're going to break those myths for you. We're going to transform you from being easy to convict, if you believe those myths to be true and conduct yourself in accordance with them, transform you from being easy to convict to being hard to convict, if you're compelled to defend yourself or your family from deadly force attack. In particular, it would be nice to be hard to convict if you've been compelled to use force against another person in defense of yourself or your family. We're going to help you make that transformation in these free webinars. We have 5 of them scheduled for April, only 5. They're all the same, so please don't sign up for more than one. They're 100% free, but you do need to sign up, and they're filling up fast, folks. When I checked this morning, these 5 seminars were 70% full already, and I guarantee you, based on prior experience, they will all sell out hard. See what I did there? There is no sales, by the way. These are free webinars, but you understand what I mean. They'll fill up very quickly. Only 100 seats at each, so only 500 total seats, and we limit it to that so I can do effective Q&A for a reasonable number of people in each of the shows. So we'll do the myth busting and Q&A. You can sign up for that at lawofselfdefense.com/hard to convict. The first of these is April 6th, which is 2 days from today. So on Wednesday, April 6th, we'll be doing the first of our lawofselfdefense.com/hard to convict webinars. I think there's still a handful of seats available for that one. When it fills up, it'll come off the option list on that link. And you can just pick one of the other dates throughout April. Again, that's lawofselfdefense.com/hard to convict. All right, folks. With that out of the way, I'll wrap up and let you all go. Just remind all of you before we depart each other's company. If you carry a gun, so you're hard to kill, that's why I carry a gun. So I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. And don't forget to catch me on Instagram tomorrow morning when I do my public weigh-in at the end of the 3rd week of my fitness weight loss regimen. Started 3 weeks ago tomorrow at 222 pounds. That's at 6 feet 1 inches in height. And we'll see what I weigh tomorrow morning. Hopefully it's something less than 222. That would be appreciated after all the the caloric restriction, intermittent fasting, and that damn treadmill work. All right, folks. Until we meet again, I remain Attorney Andrew Branca for Law of Self-Defense. Please stay safe.